Beg to mention item number 7 to 11 of DB1.
7 to 11.
7 to 11 of DB1.
Yes.
Lord.
There's another example. It is the- They've given address. Yes.
My lord, I have just been engaged. I have just been engaged.
Yes,
Okay.
fine.
Death reference. About 3-4 days back. It's a very big voluminous case.
I know.
Your lordship may fix it on next Tuesday. Court.
Huh? Okay. So, you see, now since it will go back to DB1, this issue, these cases. So we will just give a week and the exact date will be fixed by the registrar. Okay, right. On the prayer of Mr. AB. Yeah, no, AKB. AKB Leonard Senior Council for the
Appellants in 7, 8 to 11.
appellants.
Appellants in 8 to 11 and in 7, respondent.
Appearance in 7 to 11. 8 to 11, 8 to 11. And the respondents in
Item 7.
items in item 7, huh?
It-
List the matter after the week on a date to be fixed by the registry. Mr. You are for the NIA.
Malad, this matter has been transferred to against state government. So we are repeating.
See, this matter transferred to the lordship, state government by the NIL lordship as per the Home Minister's decision lordship.
Okay.
So we are representing in this matter lordship.
So we are after the week.
After lordship,
The prayer of Mr.
lordship,
ABK.
lordship, lordship,
AKB.
lordship. Obligation.
Mr. K. Gogoi appears for the state government.
My lord,
Yes,
in item number 7 and 9, my lord, we are the earlier engaged council, my lord. And we have already, my lord, written the brief, my lord. Therefore, how
Okay.
they may be, sir.
Mr.
N. Sarkar,
Gyan Sarkar appearing for the respondents
respondent in, my lord, death reference case, item number 7
in respondents in item 7, huh?
and
Please give the
9
number.
as a appellant, my lord.
And in criminal appeal 358/2018. And the appellant in 358/2018 submits that the brief has been returned to their clients and they will no longer represent the respondent in item 7 or the appellant in item 9, huh?
Along with my senior name, my lord, NNB Chaudhary.
Along with NNB Chaudhary.
Public.
May I please, your lordship? Lordship, the concern on the other side, I beg to mention item number 2, your lordship,
Yes,
of GB1. Lordship, let the matter be taken on next week because we have been informed we have not served copy to the respondents. We'll serve them during the course of the day, your lordship, today.
you're for whom?
I'm for the forest department, appellant, your lordship.
Well, acquisition was done.
The acquisition was done, your lordship.
If nothing was done,
There is no award also pronounced
Lordship, we have,
there's no section 4 notification. Nothing is there. There is the land acquisition. I don't understand. 1894, no?
yes, Lordship.
Anyway, that's what,
Our representation also, Lordship may fix this on next week, Lordship. Because our representation was
The
also.
prayer made by Mr. D. Gogoi for adjournment. List the matter after a week to be, on a date to be fixed by the registrar.
I'm highly also.
Obliged.
Madam, I just, one small thing. Yesterday, I had argued a matter, but I'm handing over the citation
My God.
comparisons. No, small, the relevant paragraphs are small, the judgments are big. Obliged.
Need to leave your.
My lord, in this matter, we have received instructions on the IA, my lord.
No objection.
My lord, we have objections, so we'll file the objection, my lord.
You have filed it.
No, my lord, we have received the instructions. I'm seeking 2 weeks' time, my lord. We'll file the affidavit.
What is their case?
There's 455 days of delay.
That much we know.
They sought condemnation.
What is their case?
Regularize, they've sought
Yeah, you are appointed against the leave vacancy.
vacancy.
Okay, you're the,
Yes, yes.
so where is it?
Lordship, she was appointed on leave.
Against the leave vacancy is not is not a vacant post.
We have invoked the 226 jurisdiction of your lordship. And
226. You just cannot, anyway, you file.
We'll file detailed affidavit.
Okay, right, Mr.
RB Goswami
R.B. Goswami, for department.
on behalf of Miss MD Bora
R.B. Goswami on behalf of Miss M.D. Bora,
for transport department.
Council for the Transport Department, submits that they have received instructions and they will be filing their written objection for condoning the delay of 455 days within
2 weeks, my lord.
2 weeks. This is the matter after 2 weeks.
DPO.
How does it? Tell.
Wait, please, your lordship. Lordship, the matter relates to dismissal of the petitioner from in a disciplinary proceeding, my lord.
So what is wrong? Where is the judgment?
Lordship, the lordship will find it annexure 7, page 98.
Page 90.
No, that is not,
That's a notification. Where is the
There is no judgment because it is.
That's the impugn order, your lordship.
He was dismissed after due inquiry. He was a judicial officer. He was, my lord, the charge against him was properly proved. He has no grievance against my lord. There is all the procedure, my lord, adopted here. There is no violation of any principle of natural justice. Only says that the incident which was happened, it was not related to his judicial work. It is his contention, my lord. From the pleadings, my lord, I came to know. But on that point, I have an answer, my lord. Because he was caught red-handed inside the, my lord, his quarter during office hour, along with one, my lord, lady of the employee of the office, my lord.
My lord, that lady was never examined in the departmental inquiry, my lord. That lady was never examined, my lord. And second, our contention is that, my lord, annexure 9, my lord, which is the appellate order, my lord. My appeal was simply dismissed without any speaking order, my lord. Annexure 9, my lord, your lordship will find it at page 107. Last page, my lord.
You are dismissed from service. Notification dated 23/70. Where is this recommendation of the High Court?
That has not been annexed by them, my lord.
No, that is your petition.
Writ petition has been filed by whom?
Me, my lord.
Then? Did you file the, so if it is there, where is the recommendation on the basis of which you have been,
My lord, we have not been provided
It's not been provided.
Not been provided, my lord. It is internal communication.
Huh?
The appellate order, my lord, is a one-liner, my lord, not, no speaking order, no reasoning has been cited, my lord. Simply dismissing my appeal, my lord. Lordship, Annexer 7, page 98. By that notification, I have been dismissed, my lord.
If there is this. Where is the inquiry report?
Inquiry report, my lord, that is started from my lord page 25.
My lord, page 25 to 79, my lord. That is Annexer 5, my lord.
So there was an inquiry done.
Well,
You took part in the inquiry. Then the inquiry report was made. Report was furnished to you to enable you to make a representation. Correct? You made a representation. And then the High Court took decision that you should be dismissed from service.
Lordship.
Now what is wrong?
Lordship, against that, I filed an appeal, my lord.
That is also dismissed.
That also dismissed, but without any speaking order, my lord, in the appellate order.
No, now, let us see where is that.
Lordship, that your lordship will find in the last page, my lord, Annexer 9, page 107. That's the appellate order, my lord.
Page.
Page 107, Annexer 9, my lord, last page of the writ petition.
আমার recommendation to person. Twenty-seven, 7/27. Recommendation to? Itu na?
Where is the recommendation of the High Court? White letter dated 27/7/70.
That is in record, my lord. Probably photocopy of the record with me, my lord. Full court.
Where is this full court meeting dated 9/3/7?
For that.
Just before this. Twenty-five to 7. We have to see the AC committee meeting of 25 to 7.
Pilot person.
9.
9/3.
No, 9/3 speaks of adopt
Yes.
the resolution.
The
passed by
administrative
AC
committee. Administrative committee is not possible. My lord, let me value.
That is here, 25 to 7.
You know?
25.
Let me say. Let me see. Let me. Sure.
You see, basically, the procedure has been followed.
No, sir.
Now, on questions of fact, that is the within the realm of the authorities, correct?
No.
So, if the technicalities have been followed, procedure has been followed, what remains?
Lord, since the appellate authority independent body, my lord, after recording its findings and in consultation with the Guwahati High Court, Honorable Guwahati High Court, that is a separate thing, my lord. There, here in this case, my lord, the appellate authority has not recorded any findings of its own. Simply a simple sentence that my appeal is dismissed.
Okay, so you are only challenging the appellate authorities' decision on the ground that it is quick. That's the only.
That, my lord, actually was passed by the government, but it was our part, I have done it, my lord. The High Court has recommended it, my lord.
No, that's
And-
all right.
and, my lord, in this type of matter, my lord, what is the, my lord, scope of judicial, my lord, review, my lord? Scope of judicial review is very limited, my lord. If it is absolutely arbitrary, not by a competent officer, then, my lord, your lordship can, my lord, interfere. Otherwise, my lord, he has no grievance against the Indian procedure, my lord. In fact, my lord, in it petition, not a single line that, my lord, there is no procedure has been not been followed. Only an argument he has adopted in his petition that, my lord, what is he has done, that is not, it is not his official duty, not related with the official duty.
It's Deepu Burman. No.
Lordship, Utpal Das, my. Petitioner's name is Utpal
Equal
Das.
does. In that meeting, my lord, other agenda also there, my lord.
Yes.
There's been given some, the function.
Let us see the inquiry report. What does it say? Page
Page 25, my.
25. And it ends at
At 79.
who is this Rupa Rani Datta?
That is the girl, my lord. That allegation is there that I have an illicit relationship. She is the office peon of Munchip.
His office peon. Then she was found under your bed.
He has recovered by police.
No, she is found under your bed.
Lord.
Then what was she
Bedroom.
doing? Playing hide and seek? Huh? How old are you? Aren't you too old to play hide and seek? Hiding under the bed. I can understand you hiding under your own bed. What is she doing hiding under your bed? Huh? And she's been found by somebody else. Is it?
Lord.
Who? Found by who?
Owner of the house.
Huh?
Owner of the
Nearby
house.
residence, my lord.
And then,
Owner
my
of
lord,
the
he
house.
was recovered by lady police, my lord. That was informed the police in, my lord.
One this. 373. One zero.
And they were, my lord, taken to the police station on that way, my lord, in even, my lord, without cloth, my lord. One of the, my lord, the judicial officer is wearing only on, my lord, undergarment only. And that was, my lord, was caught by the media also. And, my lord, that was all the public gathered there, my lord. He was rescued at 4:30, my lord, by the police. Initially, he said that, my lord, nobody inside the room was locked. Then it was, my lord, open up, and that found that she was inside the bed of this, my lord. washing machine.
Not inside, under the bed.
Under the bed, madam, in the bedroom.
But my lord,
But
that
in his
girl,
statement
that
says that
she was
nothing
on
is
leave
happening.
on, she was on leave that day, my lord.
And what is she doing? Playing hide and seek only with a gamosa? Not wearing any clothes?
And without taking any leave from the court, my lord, he went to the office.
Not wearing. I thought he was not wearing. But he issued the notification. Impugn notification dated 20/03/2017. Dismissing the petition from service. Next paragraph. The petitioner thereafter submitted the statutory appeal under Rule 15 of the Assam Services bracket Discipline and Appeal bracket was Rules 1964. What was the ground? That notification, no, the appeal, appeal dated, appeal dated 4/5/2017, huh? On the ground that the charge framed against the petitioner had nothing to do with the maintenance of judicial discipline, propriety and transparency in the conduct of a judicial officer. And as such, the provisions of clause 2 and 3 of Appendix A to the Assam Judicial Service Rules, 2003 were not attractive. Further, the presence of the peon, lady peon, in the residence of the appellant did not ipso facto reveal / prove that any unexpected / illicit relationship was present was existing. Pustam. Further, the presence of the lady peon in the residence of the appellant was personal in nature and had nothing to do with the discharge of his judicial duties in the court. And as such could not be said to be an improper conduct on the part of a judicial officer. Further, there was no proof that there was any sexual relationship between the lady peon and the petition. As such, it prayed that the peon notification dated 20/03/2017 dismissing the petitioner from service should be set aside. Next paragraph. The appeal submitted by the petitioner was on 4/5/2017 was however rejected by the first appellate authority wide notification dated 18/9/2007. Next paragraph. The petitioner's counsel submits that the rejection of the petitioner's appeal wide notification dated 18/9/2017 by the first appellate authority, being cryptic in nature and without any reasons being given for rejection of the petition of appeal, from the same should be set aside. He further submits that the lady peon in question not having been examined during the disciplinary proceedings by the charge could not be said to be proved against the petitioner. Correct? Anything else? They accordingly submit that the impugned orders dated 20/03/17 issued by the disciplinary authority, and the order dated 18/9/2017 issued by the first appellate authority should be set aside. Mr. T.J. Mahanta, learned senior counsel for the respondent number 2 and 3, submits that there is no denial with the facts in issue. That is the finding of the lady peon during office hours under the bed of the petitioner in his residence. Further, the petitioner was found to be covered only with a gamosha in his residence during office hours. At the same time, he submits that the conduct of the petitioner in being only in a gamosha during office hours in his residence, being in a gamosha in his residence during office hours, and the finding of the lady peon working in his establishment under the bed of the petitioner showed that the conduct of the petitioner was undoubtedly unworthy of a judicial officer, as inasmuch as a judicial officer would have to have only one standard, whether it be inside or outside the courtroom. In this regard, he has relied upon the judgment of the Supreme Court in the case of Daya Shankar versus High Court of Allahabad and others, 2 Registrar and others, reported in 1987, 3 SCC. One.
And scope of judicial review is very limited.
So he further submits that the scope of judicial review is very limited, and it is only meant to ensure. Now it says judicial review of a disciplinary proceeding is very limited.
Judgment, my lord, 3 judgment I have accepted.
The writ court is only to ensure that the delinquent officer receives fair treatment when a disciplinary inquiry is conducted against him. It has also only to see whether the finding of fact or conclusion is based on some evidence. Full stop. Where as the disciplinary authority is the sole judge of fact, comma. The adequacy of evidence or reliability of evidence cannot be permitted to be canvassed before a writ court. He further submits that when there is nothing perverse in the inquiry report and if it does not suffer from any patent error on the face of the record, the writ court should not interfere with the findings of the disciplinary authority. In this regard, he has relied upon the judgment of the Supreme Court in the case of Praveen Kumar versus Union of India and others, reported in 2029 SCC 471. First off, we have heard the learned counsel for the point. On a query made to the counsel for the writ petitioner as to whether the findings of fact as reported by the inquiry officer in the inquiry report was correct, comma, the learned counsel for the appellant submits that there has been no denial. There is no denial to the fact that the lady peon was found under the bed of the petitioner and in the residence of the petitioner during court working hours. It was also not denied by the counsel for the appellant that the petitioner was only covered by his gamosha, only covered by a gamosha inside his residence during office hours on the date of the incident. In the case of BC Chaturvedi,
Very suitable.
Vidhi Chaturvedi,
Which is suitable. This is Chaturvedi, my lord. This is Chaturvedi Union of India.
1995.
Yes, ma'am. It is in para 26 of the judgment. It is reflected. ma'am.
Just a minute. Okay.
Para 26 of the my lord
In the
judgment.
case of, just a minute.
Nineteen 95 6 SCC.
In the case of BC Chaturvedi, Spencer, 1995,
6 SCC 749.
1049. And which has also been relied upon
With the judge.
by in
Praveen Kumar judge.
Praveen Kumar Supra, comma, the Supreme Court has held that the disciplinary authority is the sole judge of fact. In the present case, there is no dispute fact as recorded by the inquiry officer in his inquiry report. Next paragraph. The only issue to be decided is with regard to whether a fair opportunity had been given to the petitioner to defend himself. Full stop. On a perusal, no, on considering the fact that he was given a chance to submit, on considering the fact that the petitioner had submitted his written statement of defense to the show cause notice, had also given his comments to the inquiry report, goes to show that there was no infirmity with the procedure followed by the disciplinary authority in giving him opportunity to be heard on all issues that had been considered by the inquiry report in the inquiry report. Good stop. Further, there being no dispute with regard to the facts, comma. It is seen that not only was the there has been, it is seen that there has, not only has there been no violation of the procedure, but also that there has been that there has been application of mind on coming to a reasoned decision with regard the fact that the petitioner was in his house with a lady peon during office hours. The only issue that has to be decided is whether the acts of the appellant and fact of the appellant and the finding of the lady peon in his house during office hours would amount to the would amount to a misconduct. Would amount to a misconduct
As for the appendix A, my lord.
by as his action resulted in the erosion of public confidence in the petitioner as a judicial person.
Motion to open the majority payment, majority perform to pay payment. Transfer लोग अक्सर patient भी government की लिखा है।
And thereby acted in a manner unbecoming of a judicial officer, which violated the established judicial norms as per clauses 2 and 3 of the Appendix A to the Assam Judicial Service Rule 2003. Next part. Clauses 2 and 3 of Appendix A. Two and three. This two, where is three?
Three is there, madam.
Huh?
Yes, three is there, madam. Yes, three. No, next, next.
That's it.
It went ahead. Marco
This
Pinto.
three.
Miss Pinto, sir. Assam. Oh, it's. नहीं नहीं छह बोले पाँच
This does not come into the picture.
my lord. Three is there, my lord.
No, three is there, but how is it attracted?
Oh, Miss Pinto. Let me see that. My lord.
Where's your paper?
Yes, okay. Oh, yes. এইটো ঠিক নে? এইটো নহয়, কি এইটো বেলেগ। এইটো না। He will not actually,
He does not,
he doesn't.
right,
এইটো কিয় দিছে?
clause two of appendix A to the Assam Judicial Service.
Who won?
Clause two bracket one of appendix A Judicial Service Rules 2003 states as follows.
He will come to.
Yes. You take it from here. Red portrait. Other-
That is contained in my affidavit, madam. In my affidavit, that section is
Oh,
2A is.
Anyway, right, then thereafter. In the case of Daya Shankar versus Daya Shankar Supra, the Supreme Court has held in para 11 as follows. Take this, para 11. On considering the fact that considering the fact that, and considering the facts of the case, now considering the misconduct of the officer during court working hours, and keeping in view the decision of the Supreme Court in Daya Shankar Supra, along with clause 2A, clause 2(1), of appendix A to so and so to Assam Judicial Service Rules. We are of the view that the act of the petitioner was unbecoming of a judicial officer, as as a judicial officer cannot act, should not act in a manner which is unworthy and becoming of a judicial officer. Question. Next paragraph. Though we find that the impugned or notification dated 18/9/2017 passed by the first appellate authority dismissing the petitioner's appeal is cryptic nature, the facts of the case as enumerated above goes to show that the disciplinary authority had acted by applying its mind on the facts of the case, which is not disputed by the petition, as there has been no failure, as there has been a reasoned decision given for dismissing the petitioner from service by the disciplinary authority. We are of the view that no grounds for interference with the impugned orders have been made. The writ petition is accordingly dismissed. Huh? We need something, no? We need this, no. This has to be read. We need it for now. Later, they will give back. This also we keep. We'll have to add. We'll give you later.
No,
Four to six.
May I please, your lordship, lordship, in this case, lordship, Mr. Ahmedul is here, lordship, he is on legs, lordship. Kindly pass over for time being. lordship.
This is the last item. Our DB1. Surrogacy.
Lordship, surrogacy.
There for surrogacy, I'm for if this is the Reproductive Technology Act. Though these matters have been clubbed together, my case is slightly on a different footing.
It'll take time.
It'll take time. Surrogacy, the issue to some extent has been already decided by the apex court. So what they have, their facts, I am not aware of. Because the Supreme Court has said that the couples who have initiated prior to the coming into force of the act can continue. Because there is a transition clause.
Then what about then for them, then they can continue.
I don't know their facts. They have to submit on that. But with regard to the ART Act, there's no transition clause. And the
The Supreme Court had they given guideline but commencement of the surrogacy procedure, where it start the commencement. That commencement is when it transferred from that is the freezing minor. That is the main question, whether their stage has been over or not. That commencement will start from that stage.
You don't know anything about this case.
Lordship, actually,
So we are stuck.
Your Lordship, considering this is the last item, and it will take some time if your Lordship is going to hear the matter.
No, you see, if you all are not ready, we cannot
I'm
hanging. We have to start with the other, with our normal for this also. We have got another list.
yes.
This bench is actually just,
Right.
now we are doing DB1 matter because
I
of
understand.
some, okay, because of
Let
some.
me take it next week.
next week.
Can we take, try?
Listed after a week, let the registry decide. Okay. On the part of the parties, list the matter after a week. To be decided, on a date to be decided by the registry.
Date table.
Yes. What's different? Well, oh. That is that with ethyl alcohol, that mineral. You for 2 to 5.
For my number.
Yeah, which number is that?
TV, item number 1, Your Honor. Oh, Your Lordship, pardon me, Your Lordship.
Or divorce that, okay.
I think the phrase.
This is your employee,
Yes, my lord.
then
But in Manipur, my lord, it is difficult to. In other, some cases of the Manipur also this problem creates, my lord.
army person, no?
Yes, my lord.
Yeah. What's so difficult?
My lord, we'll take fresh steps then, my lord. He's not now in service, my lord. He's army person.
But notice has been issued only
On
on
25/9/2025, my lord.
25/9.
Not returned, my lord. Till now, notice has not been returned. Today is the 1 month.
Has been issued on 22/10.
Oh, sorry, my lord, 22/10, my
So
lord.
we'll have to wait,
Yes, my lord.
right? Office note indicates that notice has been issued to the respondent only on 22/10/2025. Await service report. This is the matter after 3 weeks.
Master.
So. Difficult. Difficult case.
Lordship,
I think eyewitnesses are there.
but that I witnessed some contradiction because of which Lordship earlier granted bail to the petitioner, Lordship, last occasion. Lordship, bail was granted on
Just a minute. We are short of one paper book.
17/9.
My brother doesn't have a paper book.
Lordship, may I pray, Lordship, then any other day, Lordship, subject to convenience?
It's fast. Oh, it is there.
Oh, Lordship.
It is here.
Lordship. This honorable court pleased to grant bail, Lordship, on 17/9/2025, Lordship.
On what ground?
On the ground of evidence of PW2, Lordship, who is claiming, Lordship, may I read the last bail order, Lordship, please?
Yes, yes.
17/9/25 in the IA. Hard so-and-so learned counsel for them, who submits that the sentence passed by the so-and-so by the learned instruction judge. He submits that a reading of the evidence of PW2, who is the wife of the deceased, shows that there is a discrepancy with regard to the date of death of the deceased, inasmuch as the deceased had apparently expired on 14/5/2011 on the basis of the injuries sustained by him on 12/5/2011. Further, the FIR had been filed only on 15/5/2011, wherein nothing had been stated regarding the death of the deceased. However, the deceased had died on 14/5/2011. As per the postmortem report 14/5/2011 and the inquest that had been conducted on the said date, the applicant counsel further submits that the applicant is 73 years of age and in terms of the scheme undertaken by the so released on old and
Yes,
terminally ill. He is 70, though he got the bail, Lordship, he is now seriously ill. Today also,
Your lordship, his age, my lord.
Maybe, I don't know. Let us see the order.
17/9/2025, Lordship.
In terms of scheme undertaken by the NALSA for release of old and terminally ill prisoners, the applicant should be released on bail.
No, but apart from that, on merits also, Lordship, some discrepancies are there, Lordship. Though they are claiming them as a bail, Lordship, as a eyewitness, but also the learned session judge also did not consider the one of the inquest witness as well as the GD entry where the 161 statement was recorded, Lordship, which was in different footing case, Lordship.
Okay, let us see. There's nothing there. There is go from the FIR.
Lordship. Page 1, Lordship, in the paper book, Lordship. Date of occurrence 12/5/2011 at 7 p.m. Information received on 15/5/2011 at 2 p.m. GD entry number 328. It was mentioned. Then, Lordship, FIR, page 4.
office in charge Lala Police Station, so and so. I have the honor to state that the house of the father-in-law, the father of the second wife of my son Islamuddin Talukdar Sab, situated at Barnarpur Bagan, Biltila. The name of his father-in-law is Muhammad Jamaluddin. He had disagreement with the accused person as regards certain familial issues. That around 7 p.m. on 17/5/2011, when my son was was going from Lalamuk to his father-in-law's house at Barnarpur and reached near the Biltila Barnarpur, the aforementioned accused person out of their earlier grudge against him attacked him all of a sudden. The accused persons with an intention of killing him caused grievous injuries to him by dealing blows on different parts of his body with lathi and a 3-cell torchlight, fled him to the ground, felled him to the ground. Hearing the hue and cry, some people reached the place of occurrence and the accused person fled the scene. Thereafter, my son was admitted into Silchar Medical College and Hospital with the help of the members of the family of his father-in-law and some locals. But no sooner had my son was admitted into the hospital than he breathed his last. I therefore pray to you to investigate the matter and take necessary action and oblige, Lordship. In the said FIR, Lordship, case was registered under section 302 and 34. There are two accused, Lordship, one was acquitted. And in the FIR, just I am pointing out, Lordship, in the FIR was seen by the Magistrate Chief Judicial Magistrate Hailakandi on 19/5/2011. There was 4 days delay. Then, Lordship, the charge.
Where's the question of 4 days delay?
Lordship, that was not explained.
No, how do you say 4 days delay?
That is, it was filed on 15/5,
Occurrence was 12.
Lordship. And it was seen by the magistrate. I will come later, Lordship, regarding 19/5/2011. That is seen by the magistrate, page 4, Lordship. Then PW1, Lordship. That delay also have some legal importance, Lordship, also. PW1, Lordship, page 9. May I read, Lordship, please?
Yes.
The deceased Islamuddin is my son-in-law. The residence of my son-in-law is at Hojai. After marriage, he started staying in my house and was doing business. I know the accused persons Rahman Ali Ansari and Manikuddin Ketli. The accused Rahman Ali is my neighbor. The residence of Manikuddin Ketli is at Lalamuk Tea Estate, who used to sell fish at our village market. Accused Rahman Ali doing business of suits as hawker. My son-in-law had introduction with the accused Rahman Ali. The informant Tafazul Ali Talukdar is the father-in-law of my daughter. Your permission, Lordship.
Yes.
One prayer, my lord, as my learned friend is, Lordship. I need some more preparation in this matter, Lordship.
We will prepare together.
Lordship. So I pray, Lordship, at least some time may we consider, Lordship.
For what?
For my preparation, Lordship, because I should have to demolish all these things also, Lordship.
There's nothing here. You have got PW1,
Lordship.
PW2, and PW4.
For oral dying declaration.
That dying declaration also, Lordship, not his presence is, Lordship, disputed, Lordship.
So we'll see together.
Lordship. No, ma'am. Since Lordship, other Lordship, I need some time on that, Lordship, to prepare myself,
You
Lordship. and
see,
more
once
to-
we give you adjournment, if the next.
Lordship, actually, Lordship, with due respect, Lordship, in the last occasion, while this honorable court was pleased to grant bail, Lordship fixed the matter today, Lordship,
Yeah.
for which it's not my courtesy, Lordship, to pray for time, Lordship. Now I feel, Lordship, I need to some more
What we
preparation,
can do is we'll hear you, then we'll give you time.
Lordship.
After hearing you, we'll
Lordship,
give you some more time.
Lordship, please. I have no objection, Lordship, because I need some time on that to trace out the things in proper to correct perspective, Lordship. To
So,
citizen.
you see, we'll hear you now.
Lordship, please.
We can, we'll find out where is your weak point,
Lordship, please.
or where is your, then you can develop it further, or find somewhere to.
Pray, Lordship, for that. No problem, I'll argue on that today. But if your Lordship allow me, if any discrepancy is there, Lordship, I shall try to satisfy
On some other day.
Lordship.
Tell the bench.
You will not be here.
So it may.
The,
After 2
the
weeks,
problem is,
Lordship, please.
my brother will not be here.
Oh,
Then tomorrow I'm going to have a different bench partner.
oh. So with all respect,
So we can do it. What is so difficult here?
Lordship,
Only 1, 2, 4. They are the ones who are against it.
Lordship. That also some what I prepared, Lordship, that too, the alleged so-called eyewitness, Lordship, being on last occasion while granting bail, Lordship, I also shows that these 2 witnesses, Lordship, is not at all an eyewitness, Lordship.
Then what is so
So-
difficult now? You see, questions of fact.
Lordship.
We cannot go beyond the evidence.
Lordship, no. Lordship, I am.
The questions of
cannot-
fact are there.
What is on the record, Lordship, I should
Now-
try to say,
Only on the question of law.
Lordship, that also, on that also.
That-
So for that I pray, Lordship, I some time, Lordship.
But then who is ready for the next case?
Mr.
You're
K.R.
ready.
Chaudhary, my friend also ready, Lordship. Perhaps he has requested.
The only problem would be, my lord, it's a series matter.
So
So, my lord, lot of counsels are there. Altogether 10 accused are there. So, my lord is not sitting up, this bench is not continuing tomorrow.
I'm not continuing tomorrow.
Then it will be, my lord.
That is the problem. No, now if we give you adjournment,
Lordship, please.
we'll have nothing to do after lunch.
Oh.
This is the last, because I think we are not going to finish your case
Yes.
today.
There is 15 witnesses.
15
K.R. Chaudhary,
and all different
Yes.
accused persons.
Yeah,
So we cannot finish. So no point hearing you,
my lord.
no point hearing the next case.
Okay, series is over.
We'll do it slowly, your case.
Lordship, if any discrepancy, I pray, Lordship, on my part, Lordship, we will allow some time to satisfy your Lordship.
I will see that, we'll see that.
Lordship, please.
Because the other matter. the
Lordship,
other-
Lordship, I will not disturb that, Lordship. Lordship, I pray, Lordship, for that also to allow me time if any city,
Even if we are going to acquit you,
Lordship,
we will give you time.
Lordship, please.
So that we'll give her time. Not you, we'll give her time. Or what?
Lordship,
Supposing we find,
Ready with the case.
supposing we find that this is a case for acquittal,
Lordship,
then we will give her time to find out ways to uphold the judgment. Should it be like that? You cannot have your cake and eat it too.
No.
You've got to give the other side the.
Lordship, once upon a
Lordship.
time, I was also in that side, Lordship, for 6, 7 years. I saw, Lordship, there are bindings also. So with all fairness, I'm submitting, Lordship. If
You see, the thing is that.
problem, Lordship, I understood. I will continue, Lordship. If any, I pray at last, if any something is needed for
Then
improvement.
this bench will not be available.
No, this bench, you see, this bench will have heard mostly, we might sit together also, we don't know, after.
Lordship, please. Lordship, please. And
But his matter we cannot hear, that for sure. because it will not be completed.
Lordship.
Only one out of the 6, 7 cases will be,
Lordship.
might be done.
Correct, Lordship. Correct. Lordship, I,
Yes. So PW1, yes.
PW1. The deceased Islamuddin is my son-in-law. The resident of my son-in-law is at Hojai. After marriage, he started staying in my house and was doing business. I know the accused person Rahman Ali Ansari and Manikuddin Ketli. The accused Rahman Ali is my neighbor. The resident of my Manikuddin Ketli is at Lalamuk Tea Estate, who used to sell fish at our village market. Accused Rahman Ali doing the business of suit as hawker. My son-in-law had introduction with the accused Rahman Ali. The informant Tafazul Ali Talukdar is the father-in-law of my daughter. About 5-6 years back, during a dusk hour,
Tell me one thing.
Lordship.
Who submitted the FIR?
Lordship, the father of the victim, Lordship, deceased.
PW?
He is not a PW here, Lordship, because he died,
Oh, he died.
Lordship.
Informant died prior to the charge sheet or?
Lordship, I will verify it. Instead witness, his name is there or not. I will check it, Lordship.
His name is not there.
So really, in the list of witness, I think,
His name is there, page 78.
Hmm?
Exempted as on since expired date. Page
Expired
78.
when?
They say.
3-4. Lordship, in the judgment, I think it is mentioned perhaps. In the judgment, Lordship, page 41,
Died when?
it was not mentioned, Lordship, only led in this regard the complainant Tafazul Ali Talukdar, since deceased lodged a written Ejahat exhibit P1 to the office in charge of Lala police station since deceased, Lordship. That date was not
Anyway,
mentioned.
okay, then
Then Lordship, then second paragraph, Lordship, in the PW1, Lordship. About 5-6 years back, during the dusk hour, it was a dark night, Lordship. I was in my house. I heard halla from the
dusk, you see, there's a difference between dusk and dark. Dusk is the period between day and night.
day and night.
Okay, it's a
7
period.
p.m.
It's in the, say it's around, say now, dusk will be around 5 o'clock, maybe 4:30. It's the period between light and day.
Lordship.
I mean, light and night. Day and night.
Day and
Period, dusk.
Lordship.
In the evening.
But it was 7 p.m. Lordship.
Huh?
In the FIR, it was mentioned time of incidence was 7 p.m. Lordship. In the page 1, date of occurrence 12/5 to time
But
except
you see, when did it, the period was on, it was on May.
Me.
May.
May is correct. May that sun sets at around 6:37,
Lordship.
correct?
Lordship.
So what time was the event? When did
Date
it
of
happen?
time of occurrence 12 at 7 p.m. Lordship.
7 p.m. dusk.
Lordship.
7 p.m. It gets dark around 7 only.
Lordship. Dark started.
That's all.
Acha. Second paragraph, Lordship.
Yes.
About 5-6 years back, during dusk hour while I was in my house, I heard halla from the road nearby my house. Then I went there and saw the accused Rahman and one unknown person assaulting my son-in-law, Islamuddin, by means of a big size of torchlight and by a means of a small lathi. Here,
No, but where do you read lathi? Where's the lathi?
small weapon, Lordship. Small weapon. There
Small
are other place, Lordship, which was, but Lordship, who assaulted by what weapon, that is not clarified, Lordship.
It's okay, but accused Rahman is there.
Lordship.
That is you. Rahman is you.
Rahman is there. I tried to dispense the accused, but could not. Then my daughter Halima Begum came and able to dispense them. Thereafter, the accused Rahman, an unknown person, left the place and bleeding started from the mouth of my son-in-law. Thereafter, we took him to the Lala PHC, Primary Health Center, where from he was referred to Hailakandi Civil Hospital. Then he was shifted to SMCH, Silchar Medical College Hospital, Silchar, but he left his last breath there. Postmortem was conducted and dead body was handed over to us. The father of the deceased, after getting information, came to my house and lodged the FIR. He went there after getting the information of death, Lordship. Nobody of the PW 1 or 2 never tried to file any, lodged any FIR. That's also because while at Silchar Medical College, there was a GD entry. I'll come later, Lordship, on that. Then cross, Lordship. It was a dark night, the incident occurred. It was a dark night, the incident occurred. My house is situated on a hillock. The road is on the bottom of the hillock. The way to reach my house from the road is a slope. There are standing trees by both the sides of the way. It takes 3 minutes to reach my house from the road. Immediately, my son-in-law was referred from Lalat and Hailakandi to SMCH, Silchar, without wasting time. It is not a fact that I did not state before the police that one unknown person also assaulting my son-in-law by means of a small weapon. It is also not a fact that I did not state before the police that I wanted to disperse the accused person Rahman Ali from assaulting my son-in-law. It is also not a fact that I did not state before the police that my daughter was able to disperse them. It is not a fact that I did not state before the police that there was a bleeding from the mouth of my son. There are landed properties belong to me and Rahman Ali contiguous to each other. It is not a fact that my son-in-law died as a result of the injury sustained by falling on the way of my house, and there was a land dispute between me and the accused person, so-and-so. As such, in order to take the revenge, I have deposed falsely. Actually, the house is slope. It was a hillock, Lordship. That cross indicating, Lordship, because this man was a drunkard, smell was there. Also, that allegation part is there.
What smell?
That victim, Lordship, that deceased. Because he was coming, there was a slope, Lordship.
So just because he's a drunkard and smells
I am
of liquor, how
also not that, Lordship. That also I will come also one by one, Lordship. As per the cross, Lordship, indicating that point, Lordship, he fall there because intention of the accused to kill.
he fell.
Fell, Lordship.
So there was no assault from
No assault, Lordship.
there are cases that he fell.
Lordship, I am coming also on that part also. Then Lordship PW2. She is the wife of the deceased, Lordship. I know the accused person Rahman Ali, who is my neighbor and sells sweets, etc. in the locality. The incident took place 5-6 years back during dusk hours. At the relevant time, me and my mother were in the house. On hearing halla, my mother went to the road of the bottom of the hillock. And following my mother, I also went there. I saw the accused Rahman Ali assaulting my husband by means of a 3-battery torch. I tried to resist Rahman Ali and somehow I could not resist him. Thereafter, Rahman Ali left the place, so-and-so bleeding head and other parts of my husband's body. On seeing this, I became unconscious. Thereafter, my husband was shifted to hospital and then to the SMCH and Silchar where he expired. I know the accused Manik standing on the dock. Manik is the accused number 2, Lordship. Then cross, Lordship. The way to reach our house from the road is very slope. There was a slope, Lordship. It was a dark.
The way to reach house is very slope. What do you mean very slope? Very slope means very steep or not so steep or what? Very slope means
In
what?
the area where their house is, it is a hilly place, Lordship.
So what does it, slope mean slope?
Slope means house is in, he was coming from down, very slope means it was a very deep. In a hilly area, Lordship, in the area where it is a tea garden area, Lordship. The way to reach our house, the road is very slope. It was dark night.
This translator
Lordship,
needs to do a course in English.
Lordship.
Probably has done a course in how not to do a course in English, but has done a course because halla, making halla, on hearing halla,
Halla means
hue and cry.
hue and cry, Lordship.
Something.
Then, Lordship, it was a dark night. Apart from me and my mother, the accused Rahman Ali, there was none present at the place of occurrence. There was none in the place, Lordship, which is very clear, Lordship. As I became unconscious after seeing the blood, I could not say whether my husband was directly taken to the hospital or not. Our land and land of the Rahman Ali are contiguous. There was no dispute between we and the Rahman Ali regarding land. On the same day, my husband expired, Lordship. It's a very important, Lordship. Kindly consider that, Lordship.
Huh?
On the
Mahajan.
on the same day, my husband expired, Lordship. How we can believe she is a eyewitness, Lordship? Because the disease died after 3 days, Lordship. 12, 13, 14, Lordship. She is not a believable, it is not a believable witness, Lordship. PW2.
Not only that, there is one thing. You see, PW2 has said that apart from me and my mother and the accused person, Rahman Ali, there was none present at the place of offense.
So time declaration will go, Lordship. Sorry.
Then when you look at PW1,
Lordship.
PW1 has said that when I went there and saw the accused Rahman and one unknown person assaulting
Hello.
my son-in-law. One unknown person has not been mentioned at all by this PW2.
Yes.
One was acquitted, maybe?
He was
The one who has acquitted.
Yes.
So PW2 has not made a mention of that one unknown person. And also, PW2 has not made a mention of PW1.
No, and following my mother also went there.
Ah.
So she mentioned about,
So PW1 is this mother.
yes.
Mother.
But PW2 has not made a mention of that unknown person.
No.
Present. Present. She saw the present appellant assaulting the deceased, but he has nowhere mentioned the other person. Anyway, that is one aspect. Then the other is that PW2 says that on the same day my husband expired.
Yes.
But he died 2 days later, not on the same.
Yes.
Yes.
Then, Lordship, not every accused persons are in the no way involved in the death of my husband. I am suppressing the fact that the land dispute between we and the accused Rahman Ali, for which I deposed falsely after the death of my husband, I remain married again. After death of the husband, Lordship, she got married, Lordship, again. My response submission regarding respondent, PW number 2, Lordship, she said that there was none present. Then, Lordship, I will come on PW3, Lordship.
Yes.
PW3, page 13. I know accused Rahman Mia, but I do not know the remaining accused person. I do not know the informant of the case in the year 2011 at one night at 7 p.m. While I was returning from market, I saw a person laying in unstable condition on the road in front of the house of Johur Ali at Biltila. I saw the person was vomiting and there was bleeding from his mouth. I found Halima near the person. The Halima is PW2 Lordship. On being asked by me, Halima reported me that the Rahman Mia had assaulted the person who is her husband. Thereafter, I, along with Nuruddin, Halima, Jamal, took the person to the Hailakandi hospital by an ambulance. Lordship, they have first taken the deceased was taken to the hospital of Lala Lordship, PHC. But he is stating that I, along with Nuruddin, Halima, Jamaluddin, took the person to Hailakandi hospital by an ambulance. This, and she deposed that she was unconscious, Lordship. PW2. Even
Yeah.
I, along with so-and-so, Hailakandi hospital by an ambulance. Thereafter, the husband of Halima was shifted to Silchar for better treatment. I did not accompany him to Silchar. Thereafter, I came to know that the person expired. Police recorded. I cannot say the exact date of occurrence. I did not see the occurrence of assault. The residence of Halima is on the top of hillock. There is the PW2's residence is of the top of the hillock, that is the hill top, Lordship.
Really? Top of hillock means hilltop?
Hilltop.
I didn't know that.
It is a hillock, Lordship, top of hillock. There are some tea garden area, Lordship, is for that. Huh?
Okay. Mound type.
There were trees, Lordship. There were trees by the side of the path leading to the house of Halima. Also, some trees were kept laying by the side of the path. The way, Lordship, the husband of Halima was a habitual drunkard, Lordship.
Okay.
On the very relevant day, I found a smell of liquor coming from the mouth of her husband. He was a drunkard.
No, but then you see, there was a test done some time back where these persons had jackfruit. And those persons who had jackfruit, they had the smell of liquor.
But there is a statement that he is a habitual drunkard, Lordship.
Maybe, but then maybe habitual drunkard, but just because he was a habitual drunkard may not mean that the smell that come from his mouth was liquor. It could be jackfruit also.
Lordship, then it is not a fact that since there was a land dispute between Halima and the accused persons were implicated in the instant case most falsely. Sorry, Lordship.
No.
Yes, Lordship. We'll continue it to Lordship.
We'll continue it to. Your volume has also gone up a little bit more. He's more excited now.
Yes.
Getting the indication from your lordship regarding the inconsistencies. My lord.
The monotonous tone is changing.
My lord.
Lordship.
Towards the positive side.
Okay.
Why don't about that bit? I guess on the next item, I
Next item, they were having a problem because there are a lot of the.
we are having my item 8 to 8 to 12. That series, but it came before lost it several times already also. We are in hurry, man.
You were there.
Yes. Suman Baga is there, myself also. We are all are there.
We are doing this. You see, one thing is, my brother and I are sitting only today.
Right.
And you all are not going to finish today.
No, that.
Now, no point we hearing it.
So
What
date, my lord. Day after
okay.
tomorrow, my lord.
No.
31st.
We have fixed, no date this week.
Next week, my lord. Next week date.
Yes,
My lord. Last part of PW three, lordship, page 14.
yes,
May I read, lordship?
yes.
Last line, there was a dispute between Halima and Rahman regarding the path leading to the house of Halima, lordship, because of which the present appellant was implicated, lordship. There was a dispute, though they have denied, but it is a very independent person, lordship. He is saying that there was a dispute between Halima and Rahman regarding the path leading to the house of Halima, lordship. Then, lordship,
There was a dispute.
then lordship, PW four, lordship.
So there was a dispute. This is bad for you.
No, lordship, I think
There's a motive.
both, there is no question of motive, lordship. With all respect, lordship, entire case, lordship, with all fairness, I'm submitting, I studied, lordship. There is no
To
such,
be fair,
lordship, there is no such intention, motive in the instant case, lordship. I have gone through that, lordship. What is the cause for assaulting, killing this man, lordship? Then, lordship, PW four, lordship, page 15.
yes,
I know both the accused persons. I know the informant Tafojul Ali, the father of the deceased. The incident occurred on 12/5/2011 at the relevant time at 7 p.m. while I was in my house and was offering namaz. My villager Ashadul Haq reported me that there was a marpit going on between husband of Halima and the accused Rahman Ali on the road. On hearing this, I went to the place of occurrence with a torchlight and saw Halima was sitting with her husband on the road and there was bleeding on the mouth. Some passers also gathered there. On being asked, the husband of Halima reported me that Rahman Ali had assaulted me. That part, lordship, is not correct. As per the version of the Halima, there was no person, lordship, except these three, lordship, as per evidence of PW 2, lordship.
no, but then it can be after some time things change.
Lordship, but
It doesn't mean that the three persons were there all the time, because you see, when he went to the road, when
Lost.
PW went to, he did not see the marpit.
lordship.
He only heard there was a marpit.
But-
then this-
But my resource submission, lordship, as per the evidence of PW 2 and blood was coming, lordship, whether he was able to talk or not, able to inform,
Why not?
lordship, that
Why not?
lordship,
Just because blood was coming out,
lordship,
means that supposing your teeth is pulled out, blood is coming out.
that also, lordship, that part with all fairness, lordship, I submit, lordship, maybe may not be, lordship. There is no such whisper about the talking, lordship. He is able to talk or not. These things is not there.
Yes.
Though he has stated, but that also. Then I am coming the cross, lordship. My house is around 7-5 knolls away. 7-8 knolls away
So,
from the place of occurrence.
correct.
The place of occurrence, 1 knolls is equal to 7 hath, lordship.
I do not know how much is hath.
Lordship, I know because I am from the village.
How much is a hath? How many in a kilometer? How many hath?
That is that nearly 40 meters maybe, lordship, because
What?
8 knolls
8 knolls is
is equal to, lordship, 4 meter minimum.
4 meter. 8 knolls.
1 meter is equal to 4 meter, lordship.
1 meter cannot be equal to 4 meters. 1
Sorry,
meter will be
one,
equal to 1 meter.
sorry, 1 knoll is equal to
4 meters.
4 meters, 5 meters maybe.
Okay, so with 4 meters, so knolls, 8 knolls will be 32 feet.
Lordship, it is not a fact that
32 meters.
then, lordship, it is not a fact that I did not state before the police that at the relevant time I was offering namaz. He was in the namaz, lordship. How he can claim, lordship?
No, he's not claiming that he saw the incident.
Lordship.
He is
Not the incidents, but regarding subsequent part, because namaz is normally, I used to offer my namaz, Lordship, 7:38, Lordship. Here in Guwahati, 8:15. Namaz I also perform the namaz, Lordship. The timings of that I'm submitting. I was offering namaz. It is an independent version. It is also not a fact that I did not state I went to the place of occurrence with a torchlight. The house of Halima is around 5-6 miles from the place of occurrence. The residence of Halima and Rahman Ali are adjacent. So far, my knowledge goes, there was no dispute between the Halima and the accused Rahman Ali. It is not a fact that there was a land dispute between so and so and Raj. Halima implicated the accused Rahman Ali in the case most falsely. It is not a fact that I have stated falsely that the husband of Halima stated me that the accused Rahman Ali assaulted him. I cannot say the exact date of death of husband of Halima. It is not that I have deposed falsely. My respect submission, Lordship. As per the Halima's version, Lordship, there was none. So his presence is also doubtful. That part kindly consider. There was none except 3, Lordship.
Yes.
Lordship, PW2 already, Lordship, I have earlier one. Then PW5, Lordship.
Yes.
Is a hearsay evidence, Lordship. I also have not so important, Lordship, from outside our district. We used to so and so. I did not go to the place of occurrence. That means his evidence may not be necessary, Lordship. Then PW6, Lordship.
No. Okay, W6. Yes.
I know the accused Rahman, but I do not know the another accused person. I do not know the informant Tohojul Ali. About 3-4 years back in an evening at about 7:30 p.m. Earlier it was 7, now it is 7. While I was returning home from market, I saw in front of the house of the accused Rahman Ali, Halima and her mother was lifting Halima's husband from the ground in injured condition. That means no other person about the dying declaration recorded stating by PW4 Lordship is not.
No. There is nothing regarding some other person. He is just saying that he saw this Halima and mother
Lordship.
lifting Halima's husband from the ground.
Lordship.
He's not talking about others.
No. I am not on that. Lordship, regarding the presence of PW4 Lordship in the place of occurrence on that.
But maybe PW4 came after that.
Lordship. No, they have lifted, Lordship. Then
Correct, so what?
after
He lifted, he was lying down on the ground,
Lordship.
lifted him and then he was sitting.
That means, Lordship, earlier things is, Lordship, that regarding the version of the PW4 Lordship is not permissible in the eye of law, Lordship. Lordship, then I am on the ground. I also helped to shift the injured to the hospital. I went to Lala Hospital. Lordship, firstly, the victim was taken, injured was taken to Lala Hospital. But the earlier evidence, Lordship, they have stated it was to Hailakandi Hospital with injured, and he was shifted to SMCH Silchar. He is saying that from Lala, he was directly shifted to Silchar Medical College. Lordship, then I do not know as to who assaulted the injured. He do not know, Lordship. He was a habitual drunkard. Later on, I came to know that the accused Halima killed her husband. It is not a fact that I had stated falsely that the Halima told me that the accused Rahman killed her husband. Then PW7, Lordship. I know the accused Rahman Mia. I do not know the another accused. 6 and 7 years back on the day of morning, I came to know from the Halima Begum that the accused Rahman Mia killed Islamuddin. I do not know anything more. It is not a fact that I did not state before the police that about 6 and 1 day morning, I came to know. That means he has denied it before the police, Lordship. He has not stated the things, Lordship. Then, Lordship, PW 7, page 19, Lordship. Huh? It is not a fact, then I did not say police that about the 6 o'clock in the morning I came to know from Halima become accused Rahman Mia killed Islamuddin. It is not a fact that I have deposed falsely. Then PW 8, Lordship, page 20. On 15/5/1, Topojul Ali Talukdar got written Ejhar. He is a scribe, Lordship, who has written the FIR, Lordship. I wrote the same as per his version. Exhibit 1 is the Ejhar signature as a scribe. I am unable to recall whether Informer Topojul put his signature before me or not in the Exhibit 1. At the time of drafting, there was other people of the Lalachoda present. I wrote the FIR as per instruction of the said people, Lordship. That means as per instruction of the said people, others people, those who are. Informant version was not recorded in the FIR, Lordship. Then PW 9, Lordship, is also hears evidence, witness, Lordship. May I read, Lordship, page 21. I do not know the informant. I know the accused Rahman Ali, but I do not know the remaining accused person. About 9 years back, one day in the morning, my sister-in-law, Moina Bibi, wife so-and-so, Jamaluddin so-and-so informed me that her son-in-law died at Silchar Medical College, Silchar. She needs monetary help. Therefore, I went to SMCH Silchar and paid rupees 500 to her and saw the dead body of her son-in-law. My sister-in-law told me that the accused Rahman killed her son-in-law. The inquest was conducted. He is the inquest witness, Lordship. Then
So the other witnesses are not important.
Lordship. Then Lordship, Doctor part, Lordship, cross. What I referred earlier, Lordship, cross, Lordship, in the page 24 to save Lordship's time, Lordship. On that. Page 23, just second paragraph, Lordship. The postmortem report reflects that on 14/5/2011 at 2 p.m. having police requisition, Gungur so-and-so, OP GD entry number 274 dated so-and-so, Dr. Bedi, who was head of the department medicine, Silchar, had conducted the postmortem. As per inquest report conducted postmortem, Lordship. Then in the cross, Lordship, his doctor's cross. Some of the above injuries may be caused to a person if that person falls on any hard object from a hillock. That, Lordship, what I stated, Lordship, earlier.
That may, if he falls down from Everest also, he'll die.
Lordship, that part. Then PW 11, Lordship, IO. It's also a little bit important, Lordship. PW 11 is the IO, page 25. On 15/5/2011, I was working as SI of Assam Police Lala Police Station at Hailakandi. On that day, one Topojul Ali Talukdar of village so-and-so, Jugijan so-and-so, Hujai district, lodged a written Ejhar in our police station. On receipt of the same, the said Ejhar was registered as Lala so-and-so against Rahman Ali Ansari and Potal Ansari, detailed in the Ejhar. Being empowered, I undertake investigation of the incident. Accordingly, I visited the place of recorded the statement of the available witnesses and draw a sketch map of the place of. I also made arrangement for conducting inquest upon the dead body as well as the postmortem examination. My lord, it's a very important, Lordship. He received the FIR after postmortem everything. On 15/5/2000.
But then he received a GD entry prior to that, no?
Not only GD entry.
He received
Inquest as well as PW, postmortem was done on 14/5.
correct.
So how he can arrange everything, Lordship? How he can my result submission, Lordship? How he can arrange, Lordship? Because he has received the FIR on 15/5. I will come on postmortem and everything, Lordship, later. Just his statement, which is not reliable, Lordship. I also made arrangement for conducting inquest upon the dead body. Inquest was made on 14/5, Lordship. Postmortem was made on 14/5 prior to FIR. I apprehended the accused Rahman Ali and on my transfer, I handed over the case diary to the so-and-so successor. Lashkar collected the postmortem report and thereafter submitted the charge sheet. Then cross, Lordship. The alleged incident occurred on 12/5/2011. There is no separate GD entry. But GD entry is there, Lordship. Separate GD entry is there at Silchar Gungur, Lordship. In the postmortem as well as inquest, page 65. Page 65, Gungur OP GDNT number 274 on 13/5/2011. Page 65, Lordship, may kindly peruse.
Yes.
Inquest report. Inquest was made on the basis of Gungur OP GDNT number 274 dated 13/5/2011. Then
Inquest is on 13/5.
Lordship. Then how he is saying that no GD entry is there, Lordship? That means I did not know anything about the past incidents of Silchar Medical College, Gungur, where GD entry, postmortem, everything was done. In his cross, he has categorized there is no separate GD entry in connection with the alleged incident.
GD entry is a 13/11. Inquest is done on 14/5.
Lordship, that means he is saying that there is no GD entry. I am on inquest and everything on the basis of his chief, Lordship. He has arranged everything he is stating. On 15/5, he has received the FIR, starting investigation. And how he can make an investigation, Lordship, that FI, that is, inquest was on 13/5/2011. And very astonishing thing is that inquest witness is another one, Lordship, page 67.
Well, you see, this person, this
Lordship.
PW11,
Lordship.
he is working as an
ASI.
SI in Lala police station.
Lordship.
Okay.
Lordship.
But the GD entry has been registered in Gungur outpost.
In connection with the same case, Lordship.
So prior to the death, there was information received with regard to this injury or with regard to this incident in the Gungur outpost.
No, not as per his statement, Lordship, page 11, 25, PWL.
He is not in Gungur, he is in Lala police station.
Lordship, he has received only basis of 15/5/2011, Lordship,
Correct.
on the basis of the FIR.
So,
Lordship, his statement, entire statement regarding his arrangement of inquest and everything will go, Lordship, page 26, middle portion, Lordship. I also made arrangement for conducting inquest upon the dead body as well as the postmortem examination. Page 26, Lordship, may I kindly peruse. Page 26 of the paper book, middle portion, Lordship.
yes,
I also made arrangement for conducting inquest upon the dead body as well as postmortem examination. How he is saying that, Lordship? He has not have a no knowledge about that. Only 15/5 he came to know. And also he is saying there's no separate GD entry. That means earlier part of inquest and postmortem, nothing he knows.
correct. He knows nothing. Correct.
Which will, Lordship, also prosecution case also creates a doubt also on that also. I'm also coming on that also. Then in the inquest part, Lordship, page 66. Page 66, Lordship, whether person's body on the body, whether appears on the body healthy, last ground number 4, any other mark, backside head of injury, only backside head of the injury. Then 16, part of the body region, part of the disease affected
Side
any
head, you can say back of the head, what?
lordship.
Yes.
Then next, point number 16. Part of the body, part of the disease not affected by any kind of injuries, armed or burning. It is totally blank, page 67 of the inquest, lordship. Page 67, may I kindly peruse?
Yes.
Page 67, 66, 16, point number 16. Page 16, part of the body region, part of the disease not affected by any kind of injuries, armed burning. All point 1, 2, 3, 4, 5, all are blank, lordship. There was no such injury mentioned in the inquest. Then lordship below. SD ASI Devodash Dev. He was the IO in SI lordship in Silchar Gungur lordship, where the GDNT was made, but he was not examined. And Halima was examined.
So how does it cause prejudice to you?
Prejudice in that sense, lordship, that IO was not examined how the GDNT was made. I'll come later, lordship, on that. Also, some records are there. GDNT, I made a translation of the English translation. I'll show on that, lordship. Also, lordship. ASI, he is a listed witness, lordship, but the learned trial court below, trial judge, lordship, did not consider that aspect, lordship. And also signature of the witness of the Halima Begum, PW2. She is also inquest witness, lordship, but in her evidence, nothing. Then, lordship, in the postmortem report, that was made with reference to reference page 69. Gungur, reference Gungur OPD 274, dated 13/5/2011. On that day, GDNT was made. Then, lordship, own position. Next page, page 70. All these are blank in the inquest report, lordship, but here it is mentioned in the postmortem report.
So what do you want to say?
Lordship, I make Xerox Angeles translation. The first GD entry where made 161 was recorded of PW2, lordship. It is tutored by the police, but that was in a total different story, lordship. I am just supplying the copy, kindly if necessary produce, peruse the same, lordship, for
Give a copy to them also.
lordship, surely I will give her also. I make it translation also, lordship. It is a GDNT, lordship, translated copy is there. Next page. Page number 2. At Gungur Silchar Medical OPD, lordship, outpost, lordship.
Now, so what do you want to say? Short, make it short. What do
Very
you
short, I am just submitting, lordship, that just only 2 minutes would be required for her statement under 161, lordship. Statement of inquest witness Halima Begum, aged so and so. That my name and address mentioned here in above are true. My statement is that above mentioned deceased is my husband. On last 12/5/2011 at night, he told me that he has been beaten up by Rahman Ansari and Putul Mia. Next day, 13/5/11, his health was deteriorated. Accordingly, he was taken to Silchar Medical College at 12 a.m. night and checked up by the doctor. After treatment, he was declared as expired on night on 14/5, today on 14/5/11, his inquest was made. It is a totally different story. That means she was not present in the place of occurrence. Yes, but the learned trial judge did not taken into account of that, lordship. Only just time for
I haven't understood.
161 statement, lordship.
161, how is it? Who's 161 statement? Who's
That is
161?
PW2, eyewitness. So-called eyewitness, lordship. She was not present in the place of occurrence.
Where is that page?
That page is one in my paper book, sorry, in my translated copy. I have given translation original also I am given.
Examination of PW2 was this put, was this question?
Not put.
Then,
It was a learned session judge also did not.
but then you did not put this question to her, then how can we have?
But the learned session judge ought to have also considered that because that inquest IO was also,
Supreme Court judgment requires you to put that question to the PW, not second.
lordship. Then lordship also that IO of Silchar who was present there during the time of inquest. He is a listed witness, but that was not examined. He was not examined, lordship.
Anything else?
Lordship, and then I, with all respect, lordship, my respect to submission. Even that of it. I'm going to regulate, Now go to common position. Off. That is so. What?
Yes.
Then lordship, the accused number 2 was acquitted out of same incident evidence, lordship.
Maybe, but then I
Parity,
witness the SLN number 2 was never identified.
but PW1 is very clear on him.
Huh?
PW1,
PW1 is clear to the extent that he says that unknown person.
that unknown person was identified by other person also, lordship.
Just because one person has been acquitted does not mean that you have.
Lordship, just I am submitting, lordship, on that also, lordship. First question is that, lordship, whether any motive is there or not. In the entire case, lordship, there is no such motive is there.
That flow, that property,
That
land dispute.
all has denied, lordship,
No,
but
no, it is here. I think you were the one who read it out to us.
lordship, my duty is to
Yes,
lordship,
PW3.
PW3.
There was a dispute between Halima and Rahman
But Halima,
regarding the path leading to the house of Halima.
lordship, but Halima denied the same, lordship. Halima denied the same. Halima,
Halima might deny, but then
PW1 and 2 denied the same, lordship.
PW4 has said that he has been told.
Lordship, PW2 also and 1 also. There was no dispute between we and Rahman Ali regarding land as per evidence of PW2, lordship. As per evidence of PW2. Who is so-called eyewitness, lordship, and
So if there was no dispute between the parties,
lordship,
then why should there be any fight?
lordship,
Why
this
should
is the
they-
question.
Why should they falsely implicate you?
Lordship, they are the neighboring people, 73 age, lordship, this man, lordship,
You have got to be very clear.
lordship,
If there is no dispute between you and your neighbor,
lordship.
why should they make a false story against him?
Lordship, sometimes lordship in village area, well over lordship about that lordship. Sometimes malice may be there lordship, but
No,
intention,
you just said that there is no dispute,
yes,
no
lordship,
enmity.
no enmity.
If there is no enmity, why should they make a false
And-
case?
And our evidence of eyewitness lordship regarding is not totally believable lordship,
Not totally believable. Partly believable.
not lordship. Because she has stated on the same day my husband expired. If 161 is taken into account lordship of that, as well as
Same day, let us see the original,
it is a translate English translation.
I want to see what was the original.
I have a certified copy of that.
What does the original say?
I have a certified copy of that.
No, take the record. Just
Lordship, take it.
the evidence of, evidence
W2.
PW
Two.
two. Cross-examination.
It's
That's-
in English.
Huh?
The way to reach our house, my lord.
No, next week, of course.
No cross-examination.
On the same day, my husband expired.
Yes.
On the same day, husband expired.
Because of the reason, my lord, she became unconscious, seeing her husband in a lordship serious state.
Anyway, how does this cause prejudice to you?
Lordship,
Date has been,
that means they are not reliable at all, lordship.
but then.
Then that unconscious part also not lordship PW4 denied lordship.
Anyway, let us forget now, any citations you rely on?
Lordship, I have lordship. Copy करिए. बोलो ना. Regarding 2008 CRLJ 372. Lordship, 2008 CRLJ 372, paragraph 14, 17 and 22, Lordship.
Yes. Para?
Para 14, Lordship, may I kindly put his Lordship. 14 fast, Lordship. A fast information report cannot be lodged in a murder case after inquest has been held.
So the investigation can be done on the basis of the jihad.
That GD entry. That has not been done, Lordship. First part done at Silchar. Second part completely, as per IO's version, everything, Lordship, make it new. 161 treatment recorded in 2 times, Lordship. And also, Lordship, sending the FIR to the magistrate in a delay, Lordship, in this paragraph 17, Lordship, last line, Lordship. Middle, Lordship, as a matter of explanation put forth by the learned counsel in regard to the delay in FIR reaching to the court is not tenable because assuming that there were some court holiday, that cannot be a ground for the delay of the FIR reaching to them because requirement of law is that FIR should be reached the concerned magistrate without any delay. We are of the opinion that the explanation given by the prosecution regarding the delay in the FIR reaching to the magistrate is neither convincing nor acceptable. Here in this case, Lordship, on 19/5, it was sent to
Okay,
magistrate.
any other citation?
Then, Lordship,
How many have you got?
5, Lordship, only short. I'll.
Just give it, just give it. Enough.
Number हटा दो. Oh, बार हो लो. First DD entry. No.
Yes. Itu na.
It.
10.
10, CRL. Nine. Mujo. You just, oh, what will do? I am sorry. Okay. Sign number. Then another judgment, Lordship. It is from our High Court, Lordship. It was reported in 2013 4 GLT, page 1017, paragraph 22 and 23. Paragraph 21 and 22-23, Lordship, regarding the GDNT and non-examination of the IO, Lordship. Here in this case, it was remanded back for examination of the IO, Lordship. Paragraph 21, last. Paragraph 21, last 6-7 line. If the prosecutor omits to bring out any relevant fact or the defense elicit from the witness in cross-examination a statement which is obscure, incomplete, the defense does not acquire, the judge must bear in mind a vested right in such limited cross-examination. It is the duty of the judge to remove such obscurity or incompetency by putting appropriate question. In such a case, it is rather criminal so-and-so, the duty of the judge conducting the trial to elicit from the witness complete information so that the evidence given by him or her becomes clear and intelligible. Though this putting of question cannot be a manner as if the witness is under cross-examination, nor can be such examination be aimed at destroying or diluting the effect of the cross-examination of the witness by defense. It is for the reason that the court shall put in exercise of its power under section 165 leading the question or put word into the mouth of the witness. Then next, Lordship, in the light of the paragraph 22, law as discussed above, one cannot ignore the fact that we must point out that the conviction of the accused appellant without bringing the contents of the general diary entry as well as the evidence of office in charge. Digboy police station, where serious infirmities in the trial and the face of such infirmities, the conviction of the accused appellant cannot be sustained, and the present case needs to be remanded back to the learned trial court for disposal according to law.
Anything else?
Lordship. The 555 personal.
How many citations have you got?
Only, Lordship, 2 remains, Lordship. I'm giving the copies, only 2. Huh? That is release of co-accused, Lordship. Paragraph 32. May I read, Lordship, please?
Yes, yes.
Paragraph 32, this court in the case of so-and-so held that where there is a similar or identical evidence of eyewitness against 2 accused by ascribing them same and similar role, the court cannot convict the one accused and acquit the other. This court clarified as under, when there is a similar or identical evidence of eyewitnesses against 2 accused by ascribing them at the same or similar role, the court cannot convict one accused and acquit the other. In such a case, the cases of both the accused will be governed by the principles of parity. These principles means that the criminal court should decide like cases alike. In such a case, the court cannot make distinction between the 2 accused, which will amount to a discrimination. Then in that case also the other accused was acquitted, Lordship. Paragraph 13. 33. On careful analysis of the evidence record, we are of the view that the appellant should be given the benefit of doubt as according to us, the prosecution.
Next, what is?
Lordship. Then regarding dying declaration, Lordship. Irfan. It is a 2025 judgment, Lordship. Paragraph 65 and 66, Lordship. May I read, Lordship, please?
Yes, yes.
Paragraph 65 in so and so, Sujit Vishwas versus State of Assam reported in 2002 so and so, while examining the distinction proof beyond reasonable doubt and suspicion in paragraph 13 has held as under. Suspicion, however grave it may be, cannot be taken to place of proof. There is a large difference between something that may be or proved or something that will be proved in criminal so and so. This is the reason that the material distinction in the middle may true and must be true, must be covered by the way of clear, cognate, and unimpeachable evidence produced by the prosecution before an accused is condemned as a convict, and the basic and golden rule must be applied in such a case, while keeping in mind that the distance between may be or true and may not must be true, that the court must maintain the vital distance between mere conjecture and sure conclusions to be arrived at on the touchstone of the dispassionate judicial scrutiny based upon a complete and comprehensive apprehension of all features of the cases, well as the quality and credibility of the evidence brought on record. The court must ensure that the miscarriage of justice is avoided, and if the fact circumstances of the case so demand, then the benefit of doubt must be given to the accused, keeping in mind that the reasonable doubt is not an imaginary, tribal, and merely probable doubt, but a fair doubt that is based upon the reasons and common sense. So and so, then 66, Lordship. Benefit of reasonable doubt does not imply a ferial willow bending on every whip of hesitancy. Judges are made a sterner staff and must take a partial with the legitimate influence following the evidence, circumstances, or direct. Even applying this principle, we have a doubt as regards the complicacy of the appellant convict in the crime. These are the citations, Lordship.
Okay.
Apart-
Yes, madam.
Here in the prosecution case relies on the evidence of PW 1 and 2, my lord, most credible witness. They are the eyewitnesses to the occurrence, my lord. They are in specific terms have named the accused persons, my lord. As regards the other accused person, it is not specifically named, but as regards the instant who has been acquitted, it was not specifically named. But as regards the present accused person, Rahman Mia, these two witnesses are specifically named, my lord. Why to discredit them, my lord? Lordship, and apart from that, your lordship, there's oral dying declaration made to PW4. And another factor, your lordship, the accused person, lordship, in 313 statement has stated that he has surrendered. And why to surrender, why to abscond, my lord? Unless he knows that he is guilty, your lordship, and he's apprehending arrest, my lord. Answer to question number 13, your lordship, he said that he surrendered. Answer to question number 1, he has taken the plea of alibi, but there is no no positive evidence to that effect, your lordship. As regards the discrepancies with GD entry as well as the FIR, lordship, may I submit your laws on perusal of records? Inquest was done in terms of the GD entry. Postmortem was done in terms of GD entry, your lordship. So GD, on the basis of the GD entry, the prosecution proceeded, lordship. So lordship, this FIR, which has been lodged subsequently, lordship, lordship, it may be taken as an 160 statement in terms of PT and Tony's case, my lord. Because the prosecution,
What?
this one, the IO did the inquest with reference to GD entry number 274. dated 13/5. And in a postmortem report is also in terms of the GD entry. So your lordship, investigation proceeded well on the basis of this GD entry, my lord.
Which case you?
GD entry number 274. Case laws, case laws I'll be referring. Yes, my lord. TT Anthony is better.
Anthony with regard to what?
The GD entry. How it should be treated, my lord.
No, you need to turn up. Eh? No, no. Oh. Inquest হয়েছে জিডি এন্ট্রি কান হয়েছে না
Reference is interested.
না না জিডি এন্ট্রি টু এক্সিবিট লিখা আছে
It was exhibited.
লিস্ট করেছে
Exhibit 2.
কই এক্সিবিট করে লিস্ট অফ কোন আছে Jasmine Plaza.
Yes, what about the death? A death occurred when?
Lordship, evidence of PW2, your lordship, seeing her husband in a precarious condition, my lord.
না 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 ইনকোয়েস্ট করছে কিন্তু
On seeing this, lordship, I became unconscious. PWC stated so much.
But the evidence was given later.
Lordship, it was given later. And your lordship, it was given in 2017. FI was of, date of incident is of 11, my lord. And your lordship, the accused persons were known to the lordship victim's family. So even if it was dusk, lordship, every possibility that they will know by the post-sermon. Why to discredit their testimony, your lordship?
GD entry was not exhibited with the permission of Lordship.
This GD entry was not exhibited, but in reference to a GD entry, everything was done. I mean to say that.
They referred.
Yes.
And
Both
also
as well as in
her 161 statement of PW2 was recorded on 14/5/2014.
Compassion
Period and already 3 was available.
So the inquest was done prior on 14, correct?
Lordship.
13/5.
No, no.
No, in
No.
Inquest was done on 14/5. Page 67, I think.
yes. 14/5.
Expired on 14.
14 on that day.
He expired on 14.
So naturally, your lord, the date of dispatch was given in the postmortem report, my
But
lord.
date of death, no higher mention. Page of the say, page 60.
14/5/2011. Inquest was done on 14/5, my lord, and post-mortem, your lordship.
Same day.
Yes. Arrival at the dead house 14/5 at 2 p.m. Examination at 2 p.m. 2:30, 14/5. Lordship, may I rely on the credibility of eyewitness, your lordship?
How many citations are you?
Only two. State of MP versus Chakki Lal and others.
Citation?
2019, 12 SCC 326.
12.
12 SCC, Lordship para 12, 20,
Page के मैम
22, second, 22 and 24. And regarding the aspect of surrendering, your lordship, may I refer 2010, 7 SCC, 496. Chunni Lal versus State of
Para.
UP. Para, lordship 28. SCC para 28. These two factors.
That's all?
That's all. And your lordship, the suggestion given by doctor is just suggestive. When eyewitness's account is there, eyewitness vis-a-vis the medical evidence, my lord. So lordship prevail, eyewitness's account will prevail over the medical evidence. And lordship may overlook, may not overlook, but there might be inconsistencies because after 6-7 years, and these are rustic persons, my lord, rustic villagers, these two witnesses, my lord, there might be lordship in understanding, my lord. There might be some discrepancy as regard the date, my lord, on which date he died.
Ms. Bhuya, she has said that her husband died on the same day. She has not referred to any date. Yes, you may be right.
Yes, my lord,
It's natural
My lord.
for, her to forget
My
the
lord.
exact
my
date.
lord.
But what she said is that on the same day, I think. Just read that again.
Yeah. Same day.
On the same day. But that is actually not correct. And for the wife to get that,
Yes. No, because I meant to say, my lord, in her deposition, she said, my lord.
can you
Or-
read that, please?
Yes, yes. On the same day my husband expired. It is not a fact that in what language she deposed and what was written, my lord. Your lordship is aware of, your lordship, while translating. And she might not be aware of.
Anything else?
Lordship, as she became unconscious, my lord, so she was not sure about the, may not be, my lord.
No, this is about
Yes,
that she knows when he died.
my lord.
But that, whether that will be relevant, whether
That
that's
is,
not.
because then
Whether
if
that
you
makes
discredit
sense
the evidence of PW2, then the evidence of PW1, which remain unshaken.
On that material corroboration, they are corroborating.
My lord.
the PW.
My lord. So I refer to that reliability of the witness, eyewitness man. Regarding oral dying declaration, I may not cite any. One citation I have. 2013 to SCC 81, your lordship. May kindly have a note, ma'am. 2013 to SCC 81. Parveen Ali and another.
2013.
Two SCC 81. Parveen Ali and Anada versus State of Assam.
You have a copy?
Para 1344. I came across a judgment, Your Lordship. This person did not die instantaneously. After 1 day or 2 days, he died. So in that
There
even
is
some
no
at the
question of oral dying declaration then. Oral dying declaration is if he's
The
going to
verge of
die,
death.
the verge of death.
Correct.
So in that even if the Honorable Supreme Court has said like it may not be 302 may not be attracted. Today I don't have that copy. They should bring if they want to get some benefit. Because this person did not die instantaneously on the date of
Oh.
occurrence. Honorable Supreme Court says under 302 it may not be attracted, but it depends on the facts and circumstances of each case, might.
Might not.
That person
It was
died of
It was the
septicemia.
first time. He died of septicemia.
Septicemia, that case, my lord, I have read once, my
That's-
lord, 2-3 years back.
Out it was a torchlight. It was
Yes.
not a weapon like a knife or
Hello.
maybe 304.
And he already spent lordship nearly 3 years in the jail, lordship.
Only.
Only 3 years.
No. Earlier, right? Check it.
Earlier ki man.
No, earlier, trial or after judgment.
He just see how many years he has spent.
Lordship, if with all fair lordship, I have some respect to submit lordship. He is aged about 73 years of age.
But he has taken the life of 35
No,
years old.
that also lordship is a doubtful lordship. Regarding 161, it may be 304 part 2 lordship.
He was on
161
previous bail.
statement said that he was survived for 3 days lordship. And he was able to walk lordship. As per what?
What is the minimum that can be given under 304 part 1? There is no minimum.
15, next, more than 10 years. maybe.
No. What
Yes.
can be the minimum?
Yes, my lord.
No. Where does it say 10 years?
Mm. Oh.
Look at 304 part 1. What does it say 10 years? Is there a minimum sentence?
Huh? It's not for 10 years or more.
Yes.
There is no minimum, I think.
Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine if the act by which the death is caused is done with the intention of causing death. So minimum.
So there is no minimum. So it can be 1 day also.
He has taken the life of a young man, Your Lordship.
No, what a-
Huh? So degree on.
So how many years did he spend as a under trial?
I'm seeing that.
That trial, it was 2000.
It's a previous bail.
Maybe, but
Yes.
previous date he would have been there in jail for some time.
Lordship. It may be on the head.
Present.
He suffered a lot, lordship 2011, since 2000.
I have serious objection as regards line of giving benefit and the or acquittal, Your Lordship.
No,
Lordship may not.
Leave it to.
We are considering your last. leg
Yes,
of your
my lord.
submission.
That Your
You
Lordship,
said
yes,
About the conversion.
My lord.
That's why
Lordship.
these questions are tough.
My lord.
Yeah.
Anyway, your reservation that doesn't really is neither here nor there. If we find that he's entitled to
Your
acquittal,
Lordship will decide that, my lord.
the reservation is different.
My lord.
You can say that you can say that the evidence does not warrant
My lord.
acquittal or
My
whatever.
lord.
Not that we have got reservation.
You want three convictions for others committal for applicability. 18, 11, 16, দাদা 11
Record of that.
No. Refused. Refused. From the date of arrest, my lord, because he was surrendering,
Yes,
was arrested on 29/5, Lordship, may kindly have
29/5,
11,
11.
arrested.
Ah,
Lordship, I'm seeing when he was released on bail.
Hmm.
Record put us in the shop. Postal order bail application. Is accepted. Lordship, bail bond was accepted on 24/8/11.
24/8.
11.
So he's been there for not even less than that, more than 3 months.
Yes.
Really more than 3.
Lordship,
Nearly 4 months.
page, in the paper book, page 39, Lordship.
Yes.
He was, during the trial, Lordship, before trial, he was 86 days in the jail. Behind the bar. Page 39.
Ah,
39. Then after judgment, Lordship, he was all along and only just recently,
and when was the judgment passed?
judgment was passed on date of judgment 13/3/2023.
13/3/23.
Yes, Lordship. Page 38 mentioned it.
So not even 3 years.
Lordship. Considering Lordship his age, kindly consider that, Lordship. Because I do not know, today's morning with out of record I am submitting. He is very seriously ill, Lordship. He may, Lordship, anything. It will be on record with all submit fairness what the period he has remained, Lordship, that period undergone may be kindly considered. And I leave with the rest, your Lordship.
These are he must have done a short course in acting.
I think 73 age, Lordship.
So what? I remember this government officer who was asking for anticipatory bail.
He was in the
Yeah,
hospital,
Parkinson.
Lordship.
And he was shaking like anything. I thought his neck will just fall off. As soon as he got the bail,
Today's morning he was in the hospital, Lordship.
he can see properly also.
Considering his age, Lordship, and detention, Lordship, I pray, Lordship, whatever.
No. First we have to see whether he'll come under 304.
Yes.
Lordship.
My lord.
Lordship, I leave it to your Lordship. Lordship, this is Lordship.
How is 304 factor? You have to show us that the exceptions to 300
Yes.
are a factor. Then only 304 will come into play.
Lordship,
How is are any of the exceptions under 300 a factor? Supposing we have to hold that he is guilty
304.
of culpable homicide, then how is 300 factor? Exception 300. One is grave and sudden provocation.
Lordship, there is no such Lordship. If he have an intention, Lordship, he maybe Lordship after come with the other weapons, Lordship, so that to kill the person. He died, Lordship, after 3 days. And 161 statement, Lordship, of the before the IO of Silchar Gungur PS, Lordship,
The
showed
problem is, in your case, you've taken the plea of alibi.
Lordship.
Now, once you've taken that plea,
Lordship.
it is your duty
Lordship.
to show that
Lordship,
you are
sometimes
elsewhere. You have not fulfilled your stand. You have got to prove your stand that you are elsewhere.
in 313, Lordship,
Yes, question number 1. You are elsewhere.
Answer to question number 1.
Problem is, the witnesses have seen you on the other hand.
but Lordship, the using weapon, Lordship, to kill a person, this is also intention, motive, Lordship. Motive to kill a person, Lord.
No, but that is all right. Intention. But then the problem is 299 talks about culpable homicide. 300 talks about culpable homicide amounting to
304 part 2 দেওয়া আছে।
provided the exceptions are not attractive.
কি তাহলে? টুথ না দেন।
What to tell? How do you still bring into the
What is the date of judgment? Judgment is opposite. Double date of পরে রাখতে পারে না না কিন্তু রিজার্ভ হিসাব করে যাব পরে তুমি count করো
But 4 is not a, it cannot be said to be a dying declaration. It is only a statement made to him by the.
173. Being the
Yes, Madam Bhuyan,
My lord,
what about that PW4?
my lord,
So what he has heard is not a dying declaration. It is not a dying declaration.
lordship.
Then what is it?
Page 15.
Yes.
If it is not a dying declaration, what is it?
Under section, under some evidence.
কোথায় গিয়ে যাবো সে 19 তারিখ দেখি বলে
May not be the relevant because it was not as regards judicial proceeding, although he dies subsequently. Otherwise, section 33 would have
Then
been.
can we just ignore it? Any relationship, any relation.
It's a relevant fact, my lord. It can be taken as a relevant fact. Because lordship, section 3 of the evidence. Section 5 of the Evidence Act, my lord, relevancy. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and no others. Lordship, section 6. Relevancy of facts forming part of same transaction. Facts which, though not in issue, are so connected with a fact in issue as to form part of same transaction. Raise case change. It may be taken as a raise case or lawsuit because lordship illustration. A is accused of the murder of B by beating him. whatever was said or done by A or B or by the bystanders at the meeting or so shortly before or after it as to form part of the same transaction is relevant.
Yeah, I think in one case, well, I was sitting in court five
My lord,
earlier.
my lord.
In that case on race case, I think some judgment was.
Yes,
given.
yes, there are, my lord. I'll place it tomorrow. This case আছে নাকি? বুঝছো? Section 6. নাম্বার হলো না।
That's it, anything else? Do we have to adjourn the matter or we decide the matter?
Lordship.
Telegram.
What? You're looking, you're studying us. Studying whether I should say reserved or adjourn the matter. Huh?
If you're with due permission, Lordship. If your Lordship consider in compassionate Lordship, that can be Lordship, or otherwise may allow time.
You're going to give one answer. You cannot say this. You cannot say that if you're going to go this way, you have to give us time. If you're going to go this way, no need to give us time.
No, Lordship.
You have to, you have
No, Lordship, not on that, Lordship. With due permission, Lordship, I said. I am not on that, Lordship. If Lordship, on the some points,
basically you'll have argued. So what we'll do is we'll keep it reserved. Well, in the meantime, you have got anything to submit, you can submit. Within 2 days.
Any decision you want to rely, you give it to the court master.
Both of you.
Vale.
or Lordship, if I want to, because what is in the record, Lordship, I already placed, I cannot improve, Lordship. With all fairness, with your Lordship, believable time, enough time was given. But my resolution to submission, Lordship, at the age of 17, already he has spent 3 years, almost 3 years. So any compensation, Lordship, kindly consider the period undergone, because he will not contest or he will survive.
We are only going to start now thinking about how to go about.
Lordship.
We cannot say whether it's going to go this way or this way.
Lordship, please. I leave it to your Lordship.
So we cannot.
Lordship, please, what I
Now we
submit.
will have to go into all the
Lordship.
You might get lucky, you might not get lucky. The parents council is studying us, looking at
Yes, my
where the Ah. Okay, right. Heard Mr. K. Mazumdar, Learned Counsel for the appellant. Also heard Ms. B. Bhuyan, Additional Public Prosecutor for the state. The accused, no, the appellant has preferred the present appeal to assail the judgment, impugn judgment dated 31/3/23 and the consequential order, a sentence order dated 3/4/23 passed by the court of the learned additional sessions judge, Hailakan, In Sessions Case number 96 of 2016, by which the appellant has been convicted under section 302 IPC and sentenced to undergo rigorous imprisonment for a period of 15 years and to pay a fine of rupees 10,000 in default of payment of fine to suffer imprisonment for another 3 months. The Oh, there is a notice issued to you.
Lordship, on that I want to mention the things Lordship. Because on 10, 9, 20,
302 minimum is life sentence.
Lordship, that
How can you be given only?
Lordship, on that,
yeah.
on that notice was issued to me, Lordship, to, on that day, Lordship, I referred it, Lordship, because if the, after hearing, Lordship, on that point, Lordship, because it was 15 years, perhaps because of age, I don't know why the learned session judge, I have nothing to say because beyond the law, I cannot travel. So,
So he has been sentenced to undergo 15 years.
15 years.
Lordship,
So minimum is life.
Life.
life means life,
So notice has been issued.
Lordship.
Correct, that is also. Because if four have, if four was told, then two would have said it. So four has got no resident. Correct. Right. The prosecution case in brief is that the father of the deceased, is it? No, it starts with the thing, it starts with the GD entry. It's to the effect that GD entry was,
Not executed.
huh? Oh, GD entry was registered when?
GD entry,
Entry was registered, Lordship.
13/5.
13/5, Lordship.
Where is that?
It is in inquest report, Lordship.
Yes, yes, record to date.
Detail. It is in page 65, Lord.
When is the date?
13/5/2011. Copy of the.
One 51 statements are in English.
Vernacular.
I have made it in English, Lordship. I have given the copy of that, Lordship. Just now I given. Yes, Lordship. Extra copy, Lordship. I translated it.
Otherwise, PW2, right?
Yes.
It was recorded on 14/5/2014,
It is before the FIR.
before the. It's a real story, Lordship. I think, which was before the Gungur IO, and that IO was not examined, Lordship, in the instant case. For which I referred the judgment of this Honorable Court Division Bench, Lordship. That IO must be examined because once it's.
There are, your lordship also passed judgments.
No,
Absence of IO, your lordship may
No.
not be fatal.
no, that
If it doesn't cause prejudice.
Yes.
Lordship. Here, actually, she is claiming after,
Husband told.
yes,
Yeah. Husband told her.
may I read vernacular portion? I can translate also. Lordship. The answer টা কইতে পারবো সমটা বল doesn't sign my judgment. It now. The answer is judgment.
What about the 161 of the mother, PW1,
Lordship, her statement was recorded after FIR.
after the FIR?
FIR.
After 15.
Because she is an inquest witness. She was at Silchar with her husband, for which PW2, for which her statement was recorded by the IO of Gungur outpost, who has made a GD entry. Because normally Lordship is well aware about that.
Resident of where? Resident of Gungur.
No, they are not the resident of, they are resident of Hailakandi. The deceased, while he was alive, he was referred to Silchar Medical College. They are in the Gungir outpost. Her statement was firstly recorded under 161. That was not taken into account before the learned trial judge, for which I referred the judgment of this Honorable Court, Bircha Kurmi versus State of Assam, and which was decided on 2nd August. And that IO was also not examined, Lordship. He is a listed witness, inquest witness also. Learned, with all fairness, learned session judge has not gone through with that, Lordship. He has just relying on the FIR and everything, Lordship, but he has mandatory root of the case, which was happened at Silchar, Lordship. Gungur outpost.
Okay, look, what we'll do is, what we'll do is, you make a small note,
Lordship,
point wise.
Lordship, please.
Number 1, 2, 3, 4. What is your submissions? Note point wise.
Lordship,
Okay.
Lordship,
And then after making that point wise note, then you make another note.
Lordship,
Who said what?
Lordship.
Small. Don't make it 2, 3 sentences, one sentence each. And the judgments, Madam, yours.
Lordship, please.
How much time? 10 days.
10 days, it may be 10 days, Lordship.
10
because
days
I
time
should-
we'll give you.
I'll make it,
We'll keep it reserved
Lordship,
because we have to pass this judgment by next month.
Lordship, please. After 10th, on 11th, I will give, Lordship, I will submit. I want 12.
You give
Because
it, you give it to you give it on the first week of November you give it by 7th.
Lordship,
Today is 28th, so 7th.
Lordship.
Okay, both of
I
you.
already, last occasion, my brief notes were prepared.
Ah.
Lordship made it immediately, Lordship, but I also make it translated 161 statement because it is in Barnacular. Barnacular, I am able to.
You give us, you can take this back. You
Lordship,
can take my thing back.
Lordship, please.
And you can, and you see what you do is when you make that note, judgment dated so and so, and then that particular paragraph
Lordship,
that you're relying upon, put that. Okay.
Lordship, please. Surely, Lordship, I will.
Because, results. So here, so, hearing concluded, judgment reserved. Or should we keep it parted?
It may be kept if it pass our Lordship. After 15,
That's the thing. What we will do is, we will say parted,
Lordship.
so that because we want
If
time,
any
otherwise,
clarification is needed for, we are able to, both
so
of us will able to submit.
we'll just say this, the hearing concluded, no, just say that, heard in part, list the matter on, list the matter
The
on
10th,
10th,
Lordship. It may be on 11th, Lordship, is it?
list the matter on 10/11. Okay.
On that day we'll submit or by that?
You submit prior to that
prior to
date,
the-
or if not by that date,
Yes.
because on
I'll serve a copy,
10th we will say that hearing concluded,
Lordship.
and then we can pass it.
I'll also serve a copy to her also.
Both sides, because this is slightly contentious. You see, the section 161 statement made by you, by PW2, is to the effect that she heard her husband say.
Her husband told her.
Husband told her.
Is it a copy?
But in the evidence, it is not there.
No. It is
How she said.
Lordship,
In fact, she said that she rescued her husband and then Raman ran away.
Lordship,
Is that-
correct, Lordship.
that would-
Because of which I made it translated, Lordship, because to enable.
So there is some
Discrepancy,
discrepancy in her evidence.
Lordship.
But suppose PW2 goes, whether
Yes.
PW1
One,
on her basis, on the statement of the mother's basis,
yes.
then that conviction stand, then that has to be addressed. Suppose to go
Yes,
Lordship,
ma'am.
because of that.
And you see, PW4
Yes, ma'am.
had heard the deceased saying that he had been assaulted by so-and-so.
Manner.
Now, if that was the case,
Lordship.
then the wife was there, the mother was there.
Lordship.
She didn't say this.
Both mother and daughter doesn't say that,
Because-
later
but
on when PW4
They were sitting on the roadside, side by side.
I translate for this. If necessary, I'll give another again copy. It will tate আছে a copy. It is in vernacular language.
What it is.
Yes, are you also, yes, there is something, I mean, hodgepodge, you know,
Answer it.
the
What?
Gungur outpost and this police station, they don't know anything. there is something, there is a
For which lordship, I referred the judgment of this honorable court of 2013 GLT. Very clearly, specifically said that IO to
Lordship, may
be.
I read?
Yes.
It's in Bengali. Halima Begum. আমার নাম ও ঠিকনা উপরে উল্লেখ করিলাম প্রায় 3 মান পূর্বে আমার বিবাহ ইসলাম উদ্দিনের সাথে হইয়াছিল ইসলাম সয়েন্সর ব্যবসায় করতে বিবাহের পরে থেকে ও আমার সাথে আমার সয়েন্স থাকা শুরু করে গত বৃহস্পতিবার 12/5/2011 তারিখ রাতি সন্ধ্যা অনুমানিক 7 ঘটিকার সময়
This statement she is reading, it is after GD entry.
This,
but you have only annexed that.
No. You should go one, page number 1.
161.
And another one is at the other place.
No, whatever you've translated.
Yes, you read.
Mr. Majumdar, there are two 161 statements, one at Gugur and
Yes.
second after the
2 times the IO has recorded. Earlier IO has recorded 161. Not examined. Even earlier 161 statement was not taken into account by the learned session judge. First 161 statement is very serious, lordship.
The IO was not examined.
Not examined.
You see.
For
What
which-
you was it?
No. Hey, man, I got to answer it. কই দিলে আর বাবা? ও, এই কারণে answer হিসাবে দিয়েছে। একটু remand হবে বাবা। মানে আগত 2013 এনেকুৱা হৈছিল।
So that has to be treated as the,
একবার 161 বছর FIR রসিদ করতে আপলোড করতে হবে।
no, then the,
Same
if that is the 161, this will be. I can do that. You can do that. You can do that. IO is still alive.
IO.
Not sure, my learned friend.
the one in
Maybe,
that name is there. no?
yes. In the list, as a listed witness also her name, his name is there. He is the interest witness. For which lordship for which in earlier occasion, this
Yes, I did. Does
I referred the said judgment lordship, Bircha Kurmi versus State of Assam.
I don't know. Devdas Dev.
He was not examined. List of asset. For which lordship, sorry.
Ms. Bhuya, another thing, since the first IO did not turn up and these things are not clear, you see, because there are two 161
Lordship,
statements.
my lord.
Now, which one will we look at?
Yes,
The first
respect will-
161 in time
My lord.
does not support the second 161 given by PW
My lord.
and her deposition. is
Yes,
four.
fourth. Yes,
These things have to be clarified.
my lord.
So can we just do it like this by sending it back?
Yes, can it be?
Will they
done,
get
my lord?
remanded?
My lord, my
Yes.
lord.
It can be remanded as per earlier judgment also this honorable court, I refer the judgment of that lordship. Kindly peruse that judgment, Bircha Kurmi versus State of Assam and others. Paragraph 21 and 22. 22 is the legal point, lordship.
Direct edition session judge Hailakandi.
Bircha Kurmi versus State of Assam.
Yes, my lord.
Paragraph, lordship got it. Paragraph 22.
If are.
No, lordship, it is Bircha Kurmi, our High Court judgment, lordship. Bircha Kurmi. May I read entire judgment, sorry, paragraph 21 or 22, lordship. Paragraph 22 may kindly peruse. This case was remanded back.
And that PW4, his statement was recorded when?
By the,
Ayo.
that to be verified from the records, lordship is allowed.
CD?
PW तेरा हमने record कर ये जो तेरा record कर it is if the GD entry and PW1 statement will consider lordship, the PW4 will not come on the way lordship. And the learned, this honorable court division bench held that the such type of conviction is not sustainable in the eye of law, that to be remanded back to reconsider the matter. In the light of the law as discussed, one cannot be ignored the fact that we must point out that the conviction of the accused appellant without bringing the contents of the general diary as well as the evidence of office in charge, Digboy Police Station, Apurva Soikia had serious infirmities in the trial. And in the face of such infirmities, the conviction of the accused appellant cannot be sustained, and present case needs to be remanded back to the learned trial court for
On
disposal.
15/5/11, your lordship, Mosaid Ali,
11.
yes, last call.
That is after FIR lordship, not in GD entry time.
Instead of remanding back, we can also send it back to the trial court for recording the evidence.
Yes, lordship, that can be done.
With the IO.
Yes,
Lordship.
That can also be done.
That can also be. Here in this case,
Setting aside.
Yes.
And after that comes, that can also be done.
That can be done.
But
That-
otherwise, we will just have the-
because he is on bail, your lordship. This person, accused person is on bail.
you will not.
Lordship may send the matter back, ask the additional district judge to lordship, session judge to take the evidence of this IO.
No, we can set aside. Because you see, he might want to come to a different finding now. He might
Yes.
come to a different finding. So we can set aside, we can say that whatever evidence has already been recorded, that can be looked into again. With the added evidence testimony of this.
You as well as the lordship,
Otherwise.
as well as
if we
PW2 lordship.
Leave it as it is, and only to ask for the evidence then. Everything, yes, because we do not know what evidence he will be giving.
My lord, on the basis of the GD entry.
Yes.
Yes. Correct, lordship. And regarding PW2 also lordship.
That's safest. So we can only just say that whatever evidence has already been recorded, that should be looked
Re-examined.
into, along with the fresh evidence that is to be recorded of the IO.
IU as well as PW2 lordship. Because she has made a statement before the,
Once the investigating officer is giving the evidence, that thing will get cleared. Then.
Ah.
because,
PW2,
Maybe cross-examination we can.
And further examination of the witness. And further examination.
Cross-examination.
Further examination and cross-examination.
lordship.
This is what was done in.
Further examination হবে। Judgment of the July different. তুমি আসিলে না। Post office club.
Bircha Kurmi. This is Indira Shah. I answer it.
It is reported in 2013 Ford GLT lordship.
Huh? Take some time. Huh? It will take some time. We can calculate. It takes some time. It will get- it's not to the- Yeah, so hearing concluded, order reserved, judgment reserved, huh?
And we may not give that.
No need, no need.
Thanks.
I think for you, job done. That is what you wanted.
No, lordship, with all fairness, lordship, my duty is to place the correct thing before your lordship. I want whatever the decision from this honorable court, lordship, but I found, I personally feel that this man has not get any justice, non-examination of the IO as well as PW1 that is from Silchar. That may not be 302, lordship. Because her,
That we have to give a small note about that Gungur thing.
lordship, please.
But just
Lordship, may I pray one thing?
No, you give a copy, you give a correct note. As the whole, just give the whole note.
Lordship.
Note.
on that.
Small point.
It's not
Yeah.
clearly- These things are not clear here.
That, the 161 statement given by all the witnesses on the basis of the GD entry and subsequent
What was
afterwards. Who are the ones who gave two 161 statements?
Lordship.
All
I
those.
have also given, all right, I'll pray this.
Second.
And the judgment. Madam, you also can give if you, if
We
it,
don't have, a copy will be like.
not, okay, not it.
Only that part, otherwise, and tomorrow itself,
Lordship.
we are reserving it.
Lordship.
You can do it, I think.
Lordship, please. And
And what
if
is that, we have said that the inquiry officer, the IO, evidence is not necessary. What is that?
Husband's my lord, lordship had passed on once.
I had passed DV. No, not like that, you can, because I want you to
On
say.
examination of IO.
Some prejudice, yes, it has relevance, and the prejudice appears to have been caused in this case due to this fact.
that,
Oh, here I have got a judgment, non-production of GD, not fatal. 2008 5 SCC 368.
Contextual.
No,
These
non-production,
issues are all contextual.
non-production is not the issue here.
Yes,
The issue is there are two 161 statements.
Yes, my lord.
And there are some 161 statement, which is a total variance with what has been recorded in the trial.
The inquest is in terms of the first ED entry, that
Mhm.
IO is not examined.
Lordship, may I say one thing?
Says he doesn't even know.
Lordship,
how much
the office may be directed to make it translated, Lordship, for convenience of this honorable court about the GD entry record, Lordship. It is in vernacular, so kindly office may be make it translated so that to this honorable court can give appropriate things, Lordship. This is
Lordship.
only 2, 3, 4 page. 2, 3, 4 page, I think. GD entry.
এটা পাৰিব নেকি ওলাব?
অ।
96 to SCC 317. Lordship, non-examination of IO doesn't per se vitiate the trial. 96 to SCC 317, Bihari Prasad versus State of Bihar.
1996,
To SCC 317.
217,
Yes, 317.
317. Non-examination of
IO.
I think.
What about the other one, non-production of GD entry not fatal?
Lordship, just. Yes, ma'am. 2008. 5 SCC
Yes,
368.
para?
Oh, para, not mentioned here.
Not mentioned. Okay, no problem.
And this judgment, Lordship, it is reported in 2013 Ford GLT. I've given the copy of 2013 Ford GLT, page 1017.
What is the thing?
Lordship, regarding the examination, non-examination of the IO matter was remanded, paragraph 22, it was mentioned. Because it is fatal, the Lordship prosecution case. 2013 Ford GLT, page 1017.
1017.
It shall be.
I've given
Remanded due to non-examination of IO.
IO who recorded the, who made the GD entry first. May I? Party's name, may I refer, Lordship?
Yes.
Bircha Kurmi versus State of Assam and
Bircha Kurmi.
Kurmi,
KUR.
KURMI versus State of Assam.
Yes. Okay.
It was decided on 2nd August 2013. Lordship.
Second.
August 2013. I've given the photocopy of that,
Okay.
Lordship.
Yeah.
Much obliged, Lordship.
Yes, anyway, no point. There's a lot of issues there.
Lordship, please.
Lordship, one more submission to make, non-examination of material witness. Although this witness is a material witness, Lordship, the other prosecution witnesses improved the case, then Lordship, it may not be fatal, my lord. Although it's a material witness to the prosecution,
But when their evidences, when their testimonies are at variance with each other, then what do you do?
regarding the date, regarding the occurrence,
That
my lord,
161
to
statement.
161 statement, that I have to see, my lord. That I have to see. One, my lord, in the GD entry, my lord, on the basis of GD entry, it was made, my lord. So, Lordship, it would be taken as a 161 statement.
No.
So it will be like, because investigation progressed well on the basis of the GD
It will
entry.
be taken as a 161.
Yes,
What about the subsequent statement?
subsequent statement, my
Yeah.
lord.
What will it be considered to be?
Lordship, that evidentiary value I have to see, Lordship. Because this IO didn't say anything before the court.
No.
Yes, my lord.
That's why we are thinking of.
My
You
lord.
see, the thing is that there are two 161.
Yes.
They are both at variance with one another. If they are at variance with one another, straight away, even before the testimony is given in the court, I mean, the reliability of that witness goes even before appearing before the court.
Then, Lordship, there are two 161 statements of PW2.
Ah.
Then if it goes, my lord, then still then the evidence of PW1 will remain.
How this
But
story-
PW1 is at variance with PW4. Four.
We are only trying to collect all the
know.
facts and do what is.
Now, which evidence should be accepted?
Yes.
Can we say that only PW1 is the best witness? PW4 is not the best witness. Because now it basically says what? That the evidence given, it is an exception to that hearsay evidence.
Hearsay,
And it should be spontaneous.
continuous.
One doesn't talk about that evidence being given to PW4 by TPC. PW1 doesn't talk about it. PW
Doesn't say, she doesn't say, my lord.
And PW.
And PW2 was sitting with the husband.
Correct. Even
When the deceased had told the fact to PW4.
even mother was there.
But
according to
Lordship, 161 while recording before the IO of the person who was from Gungur PS police station, Silchar, he has stated in a complete different person, which will go PW1 and other witnesses, Lordship. PW2, 161, which now referred, Lordship, I have given the translation. It will go, entire case will be reversed, Lordship. Maybe injury or anything, Lordship, that is also not very doubtful.
So you just see PW2, PW1, 2,
And four.
For their 161 statement.
And
We'll see. And the-
at the end of the day, these are recorded by police.
You see, the problem is, this is a death case. I
Yes.
mean, murder, death, murder. Now, we have got to take it seriously.
Yes.
So, we have got to be careful.
And DSIO comes up before the court, didn't say anything. He doesn't talk about any of the witnesses except two.
Since there is no other deed.
My lord.
Yes.
To 15. This is categorical deposition.
So,
Request is done as per the 13.
Yes.
so the police station does not know what the outpost is doing.
Yes. Actually, by virtue of the second FIR, he has started everything, second IO, the IO who has recorded his statement here before the court. But he has not mentioned about the GDNT as well as 161 statement before the, and it was the bounden duty of the learned session judge as per 165 of the Evidence Act. He should have to, maybe both the side, public prosecutor as well as the defense lawyer did not place the things, but the learned court, which is referred in the Bircha Kowari case, page 21, that the honorable court must have to see all these records about where is what, even says it is not like a postbox.
You please give the note by tomorrow.
Yes.
Because we have got to pass the order by day after tomorrow.
Lordship.
Oh, so it's 28, 29, 30, 31st. By 31st.
Oh, otherwise.
That 1 month. That end of the month thing is.
I'm grateful, Lordship. Take time, valuable time of this honorable court, Lordship.
Well, that's what we are, that's what our job is. We have got to listen to you all.
And my
And,
duty,
and goad you to complete your job because you were scared whether you should, whether we would be receptive to you or not.
Lordship, as my senior M. Majumdar sir told me that you should tell the entire facts while arguing the criminal appeal case. To say the court, it is up to the court, they may consider, maybe one point may come, take into consideration of that. Last night, I feel that I should have to place this GD entry. So that to get the real things, I am not, whatever the result would be, but the innocent person,
Yes,
one
lordship,
innocent
one should be honest to the court, my lord.
I should be honest to the court also, to inform the court how these things are dealt.
Huh?
A man is suffered like anything, Lordship. Several years old man, from 2011 cases running, what the learned court below has done, Lordship, by with all fairness.
Because we don't know how to go, this way or this way.
Lordship,
It's slightly confusing. So there's nothing very, there's no clarity on this.
Lordship,
So let it be cleared by the time.
Lordship,
In the meantime, he'll remain on bail.
Lordship, please.
You know.
Much obliged, Lordship.